The Courts of Justice Committee will come to order, and the clerk will open the roll. Mr. Chair, you have a quorum. Great. We're going to start, and I apologize to the folks who have signed up. We're going to start with Senator Norman with Senate Bill 954. We'll get to the sign-ups in just a minute.
Thank you very much for the courtesy, Mr. Chairman. Senate Bill 954, excuse me, is the evolving first offense of possession of marijuana. As all of you know, I started out with an altruistic objective of decriminalizing possession of marijuana on first offense. Unfortunately, commonsensically, I get grounded by practicalities on occasions. And it was rather obvious to me, particularly in light of what the other body's subcommittee on criminal justice did with a comparable bill, not an exact reflection of it. They dismissed the bill 7-1. So in an effort to try to reconcile my own approach, I toned this bill down, and it's interesting when you try to do something practical to get it through the legislative process. There are always those enthusiasts who want to lambaste you for having no guts on it, but I was trying to be practical. So what is before you right now is a bill that does not decriminalize the first possession of marijuana, but what it does do is make some significant adjustments. And it goes further than Senator McDougal's bill. Basically, on a first-time offense, you're still charged with an unclassified misdemeanor. There is a deferred disposition very similar to what's currently in the statute. The only significant change is that as a result of decisions that were made on a federal level, there is not the mandatory suspension of your driver's license. And I'm sure you all are aware that the feds have changed their approach on that. What it does is it requires a deferred disposition with the same punishments that are now in the statute. And at the conclusion of the deferred disposition, if you have complied with all of the restrictions that have been placed upon you, you may have your arrest record expunged regardless of your age. A previous bill had it at 21 or younger. It does not impact any other statutes. I've heard all sorts of ridiculous things, like it's going to create more problems with driving under the influence of drugs. It doesn't change a thing. I know an awful lot about that area of the law. The law will remain exactly as it is. I know the Chief of Police Association had looked at an earlier version and said that they had some concerns. And one of the recent concerns that they brought up were compliance with federal legislation on college campuses. I did take the opportunity, and Mr. Chairman, as you know, the Crime Commission spent a lot of time looking on this, and we've got a real basis of information, and I want to thank them for what they did. But if, in fact, there's a problem with higher education compliance, I am perplexed why Connecticut, Illinois, Maryland, Minnesota, New York, Ohio, Vermont, Delaware, Mississippi, Nebraska, New Hampshire, Rhode Island, Missouri, Montana have all managed to deal with that, and they have institutions of higher education there. Another component that I put to it, and then I'll shut up, is that I created two things. There were some concerns about a database. I've worked with the Virginia State Police so that people will not get multiple opportunities at a first offender status, that they're going to maintain a separate database And that before someone goes to court, that either the court or the prosecutors can check that database to see whether or not someone has been given the benefit of the first offender status. So you will only get that one bite at the apple. Otherwise, you will be treated on a criminal offense. And then I created this heroin and opioid fund to where some of the money will go on that for an educational purposes only. The only thing I would say is I gathered Crime Commission gathered some statistical information for me. In the last 3 years, almost 69,000 people in Virginia have been charged with possession of marijuana first offense. If in fact $250 of that is applied towards the heroin opioid education fund, that's just slightly more than $17 million that would go into fighting that epidemic situation that we're dealing. So there it is, not decriminalization, just winding it down and your ability to expunge it.
Well, Senator Norman, let's get the substitute before us. Senator Norman moves the substitute. Senator Stewart seconds it. All in favor of adopting the substitute signify by saying aye. Aye. All opposed. Substitute is before us. Anybody have any questions of the patron?
It does need to go to finance, sir. We've got to tweak some of the numbers, but there's money in the budget to do it, but I think we can make it self-funded.
Senator McDougall.
Mr. Chairman, and I apologize, I had a sick little one last night, but for being late. But how, if the charge is expunged, how are we going to know that it was there historically? I mean, logistically, how's that going to work?
Thank you. I think I explained that before you got here. The Virginia State Police have agreed to create a separate database that's going to only be accessible to prosecutors and the courts. And they will run it through there and determine whether or not you've had a prior deferred disposition on it.
Any other questions? All right, let's hear from those who wish to support Senator Norman. Senator Eben, do you have, you standing up for a reason?
I have a very similar bill. I don't know if you want to hear that before you make the final deliberation.
I would say, Mr. Chairman, the senator and I chatted and had some brief conversation about a reconciliation, and he expressed his preference to present his bill. So I think I would prefer to have my bill stand independently and let the committee exercise its judgment at that point.
And I think that they are sufficiently dissimilar that we can move, and I think Senator Favola has one as well. So let's move through these, and for the patrons, other patrons who are here, we're going to do these three bills first. So if you want us to call you, we'd be more than happy to do so. So sorry for the inconvenience. It may be very entertaining, so you may want to stick around. All right, let's hear from anybody who wishes to speak in favor of Senator Norman's bill.
Good morning, Mr. Chairman. I'm David Ledbetter. I'm the Commonwealth's Attorney for the City of Waynesboro. I'm here on behalf of the Virginia Association of Commonwealth's Attorneys. The position that the Commonwealth's attorneys have taken as a whole, we came to a consensus that we oppose the decriminalization of marijuana in Virginia, so we liked the bill and supported on that. With respect to what we wanted to see, we're all universally, I think, consensus is to be opposed to decriminalization. We were split as to whether to leave the status quo or to change it to where it's a finable offense. It's about an even split between the Commonwealth's attorneys that are present. So we don't take a position as that, but we do like that Senator Norman has saw fit to not decriminalize it. We do have some concerns about the expungement side in that we see that expungement is a unique remedy and it's for those that are truly innocent, and this would open it up to somebody who's not truly innocent. So that does give us some pause for concern, but otherwise we're overall in support.
All right, well, thank you very much.
Thank you.
Welcome.
Good morning. Morgan Whalen from the City of Norfolk. We're supportive of this legislation, and we thank Senator Norman for his efforts.
Thank you.
Mr. Chairman, Roger Wiley speaking this morning for the Virginia Municipal League. I have trouble saying that. I don't know why. The league does have a position in favor of decriminalization of small amounts, simple possession, and they think this bill is a step in that direction, and they do support it. I promised my other client, the Virginia Association of Counties, that I would make it clear they don't have a position on this bill.
All right.
Thank you.
Thank you very much. Anybody wish to speak in opposition to this bill?
Mr. Chairman, members of the committee, Claire Guthrie Gastanaga on behalf of the 42,000 members of the American Civil Liberties Union here in Virginia. We much prefer Senator Evans' approach in Senate Bill 111, which is to decriminalize marijuana. This bill is not going to get us where we need to go on a number of levels. One, continues to allow police to use the potential that there might be a crime of marijuana, like I smelled marijuana, as a way to interdict somebody and stop them and frisk them, and that's not going to change under this bill as long as it's criminal. Two, we have a very gross disproportion of prosecutions, arrests and prosecutions for marijuana offenses in Virginia. 8 times more likely to be arrested and prosecuted for marijuana in Arlington, 3 times more likely across the state if you're black. And this is not going to address that as long as it's criminal. 3, we have some pretty serious concerns about the privileging of people with money that this bill does. Not everybody has $300 to pay an expungement fee. And so this is going to essentially be a remedy or a relief for only some people, and it will privilege some people over the others. And if you really care about the fact that we had 69,000 arrests and the costs in the criminal justice system of those arrests for something which is a low-level offense, and frankly, we're in favor of legalization as well as decriminalization. If you're really concerned about the cost of the criminal justice system of prosecuting these offenses, this does not get you anywhere. In fact, it probably increases the cost by setting up new systems and data management systems that don't currently exist.
Claire, can I
Sure.
just ask you a quick question? I mean, if your choice were this or nothing, would you still oppose this?
We don't think this does anything other than the current law. I mean, in the sense
Do you
that
prefer
it
the
doesn't.
status quo?
We
Okay.
are not in favor of passage of this bill at this time.
Loud
Mr.
and
Chair,
clear. All right.
Mr. Chair,
Who's that? Senator Peterson?
I have a question. Maybe it's for either Senator Norman or Claire. In regard to the expungement fee, is there an informal pauperous for that? I mean,
Not that I know of, sir, Mr. Chairman, not that I know of.
All right. You want to ask Tommy, Senator Norman, or?
Yes,
All
sir.
right.
Claire, just.
And I, just so you know, I started this, I'm sorry. But we try not to be discourteous or to our witnesses and put them on the witness stand, but I think that Claire can handle it. Go ahead.
Thank you, Mr. Chairman. I've been trying to do so for quite a long time.
Yeah, I'm pretty confident, so.
Thank you, Mr. Chairman. Claire, just so I fully understand, you would prefer to see a number of bills die a fiery death in the court subcommittee. Is that what I'm hearing, rather than making progress in this committee?
Mr. Chairman, I think the characterization that I'm not in favor of making progress is not correct. I'm in favor of making progress, but I think this bill is the illusion of progress and not in fact progress.
All right, Senator McDougal.
Claire, in reference to the probable cause issue, and I don't know the numbers on this, but my guess is most marijuana convictions come out of some sort of traffic stop, a vehicle-related situation. If an officer smelled an odor that he associated with marijuana and witnessed any sort of driving behavior, wouldn't that still be some probable cause, just as the odor of alcoholic beverage in any driving behavior is probable cause for him to continue, for that officer to continue an investigation?
Mr. Chairman, Senator McDougal, there are serious concerns that have been raised about whether officers are in fact trained to make those determinations about the smell of marijuana. And in fact, there is some evidence to suggest that they say that they did in order to get where they wanted to go. So, I mean, as long as it's criminal. Now, obviously, we don't support drugged driving, and we don't believe that people should drive impaired. And if somebody illustrates that they're driving impaired, there's nothing that's going to change the ability to arrest them for that or to ticket them for that.
Mr. Chairman,
Senator McDougall.
I would say that, as you know, ethyl alcohol is odorless and colorless, and so the odor associated with that is zero. It has to be an alcoholic beverage. So I don't know that I'm seeing any distinction whatsoever if somebody smelled the odor of alcohol, any sort of driving behavior, and then began a line of questioning about whether they were under the influence in the same way that you would do for traditional DUI stop. So I guess I'm not convinced on that's a statement more than a question. I'm not convinced on the probable cause change that whether it's criminalized or not criminalized would have on traffic stops. If it was on the street stop, certainly I think that you're accurate, but traffic stops, I'm not sure are going to make a difference.
Mr. Chairman, Senator McDougall, I would hope that you're stopped on a traffic stop because there's observed behavior that suggests that you're not driving properly. In fact, a lot of the kind of rousting that we see is not in traffic stops, but in fact on the street, people who are homeless, people who are alleged to be loitering, those kinds of things.
Mr.
And
Chairman.
I hesitate to even ask this question, I'm sorry, but Claire's doing such a good job of parrying these questions. But did you all support the distracted driving bill?
No, Mr. Chairman.
Did you all actively oppose that?
No, Mr. Chairman.
Really? Okay. Mr. Benjamin.
I was only going to add that there is a distinction, Mr. Chairman. If an officer detects an odor of marijuana, then that will lead to a full search of the vehicle, unlike a typical DUI stop.
Right. Okay. Thank you.
Mr. Chairman,
You're a
I
good
have
sport. Appreciate it.
Mr. Chairman, I have a question.
Senator Edwards.
I'm trying to find in the bill where it has anything to do with stopping somebody, the probable cause. It's not in there. Okay. So I'm wondering why we're talking about that part. Anyway.
Once again, speaking of illusions, the illusions of totally decriminalizing or legalizing is not in the legislative agenda this year. It is perplexing to me as I listen to the ACLU. It kind of affirms maybe I am moving in the right direction. And I say this, it's perplexing to me where you all know that I started coming at this from young people who are convicted on that first offense, and how even though there's a disposition with a finding other than not guilty, it can stick with them, and that's where the expungement came from. And it's perplexing to me that group would oppose even the expungement of that, which really was the impetus for it. But anyway, I'd respectfully ask that the bill be reported and re-referred to the Committee on Finance.
Senator Saslaw.
Mr. Chairman, I move we report this and refer it to Finance Committee.
All right. It's been moved and seconded. Any further discussion? Hearing none, the clerk will open the roll. All right. Well, thank you very much.
Thank you, Mr.
Next,
Chairman.
we're going to take up Senator Evans' Senate Bill 111.
Thank you, Mr. Chairman, members of the committee. This bill has to do with the decriminalization of marijuana. And rather than, let me just get my witness's testimony to my phone. There are a number of negative effects of our current law that are not addressed in the previous bill that mine would address. And I'm going to start by reading testimony from a small business owner here in Virginia. And he wanted to be here today but was not able to. He said, my company works throughout Virginia and in the Loudoun County area, been in business since 2005, received awards from insurance carriers for being one of the top insurance carriers in the Mid-Atlantic, and so on. We employ 7 full-time employees, have total annual payroll in excess of $400,000, and he wants to convey his perspectives as a parent and an employer. He's the parent of a child who went through the process due to a simple possession of marijuana charge, and his child was a local high school graduate, ran track, graduated with a high GPA. accepted to all the colleges he applied to and elected to go to work rather than attend college right away. He's excelled in his full-time employment, and he saw firsthand after his son received the charge that he had to call a phone number every evening to see what his color code was for the next day. That's for random drug testing. When I met with probationers, I learned that they have to call in every night for this code, and if they're to be tested the next day, they had to report either at 10 a.m. or 3 p.m. and wait up to 2 hours due to the volume of people waiting for the same reason. He could not even travel for work without getting permission from the probation officer. So planning business travel was very difficult. Between the 2-hour wait and travel time, he could be away from work for up to 3 hours during the middle of the 8 to 5 day. He noticed when he took his son to some of these appointments that there were others who had to leave their employers, and he met others who had caused a hardship in that he met a young man who was fired from his job because he had to undergo the random drug testing. And I think this is really important, this next point. He said, it definitely causes an extra hardship on families that don't have the resources to hire attorneys. As with the classes they're required to take, court costs, attorney fees, the process cost us over $3,000, including legal fees. So his son was lucky enough to have a parent who had the resources to hire an attorney, pay court costs, etc. That was, again, for a simple possession for a small amount of marijuana for personal use. And then he talked about his employee who was caught in his backyard with a small amount of marijuana for personal use. And when people smell smoke or smell marijuana, it's often on the street or in the backyard, not just in a car. And obviously, if it's in a car with driving behavior, that's something else that needs to be penalized. Anyway, this gentleman was fired, the young man, and when he did a background check on the prospective employee, the only criminal history he had was simple marijuana possession charge. And he said he particularly feels with companies like Amazon and others looking to locate major office in the Commonwealth, we need to have reasonable, fair laws that contribute to retaining and attracting employees and employers, and laws that are not unfair to the economically disadvantaged. And he notes that we're competitive with Maryland and D.C., where employers can employ millennials without fear of them receiving drug charges for simple marijuana use and having to take lots of time away from work, causing hardship for the employee and the employer. And just to address a few things, I didn't get to hear all of Senator Norman's presentation, but I think you probably went into the fact that the U.S. Drug Enforcement Agency finds marijuana demonstrably less harmful than other illegal substances. And further, the negative effects of current law is widespread. One American is arrested every 45 seconds for marijuana possession. And it will save us on law enforcement costs here in Virginia. We spent in 2010 $67 million on marijuana possession enforcement between 33.5 million state police, 23.3 million judicial and legal, and 10.5 for corrections. And we know, and I've got lots of points on this if you care for it, that marijuana is not a gateway drug. It's not more dangerous than alcohol or other substances. We also know from states that have decriminalized, I've got a number of studies by respected studies about how states that reduced their penalties or decriminalized did not see evidence. This is from the National Academy of Sciences. There is little evidence that decriminalization of marijuana use necessarily leads to a substantial increase in marijuana use. So what I'm asking you to do is to reduce the penalty for marijuana use. It would still be a crime, but I'm asking you to reduce it to a monetary fine, no possibility of jail time, no random drug testing to disrupt employers' and employees' lives, and no record of a criminal possibility for a criminal offense. And with all due respect to Senator Norman's bill, he has a process in there for expungement. But I would maintain that the same lower income, often minority people who are charged with this crime may not have the resources to get an expungement. Now, Senator Norman and I discussed the difficulty or ease of expungement, but I just don't think that once you get charged and you've paid your fine, that you'll have as much appetite or knowledge to go through another process. So that's the bill in general. It has 3 levels of penalties from $50 to $250, and this bill does nothing to the penalties on distribution. If you sell marijuana in Virginia, still a crime, still the same crime.
Right.
So I'm available for your questions if you have any.
All right. Anybody have any questions of patrons? Senator Peterson.
Senator Edmund, a couple questions. What would the effects be if you were convicted, or not, I don't know if convicted is the right word, but if you were charged with a civil penalty on one, driving while you were high or driving while you were in possession, and two, your ability to own a firearm?
Well, the firearms I believe would be easier to own a firearm because you wouldn't be prohibited. Counsel can correct me if I'm wrong. This is not, currently, I believe that because it's criminal charge, does it impact your ability to own a firearm? Or is it based on a misdemeanor, it's not?
It does not impact.
Okay, so there'd be no change there. And then your other question was about driving while impaired? Yes, sir. This bill is silent on that. It's just dealing with the possession itself.
Okay. Going back to the.
All right, Senator Peterson.
Yeah, going back to the firearm, if I look at lines 416 and 417, it says a civil violation under 18.2-250.1 shall be considered a conviction for purposes of this section.
I apologize.
So I didn't mean to trap you there, Senator.
No,
I was
I
actually
don't
trying
know.
to highlight the fact that.
No, I don't know why it's in there because I didn't intend, it says right here under that purchase. Yeah,
I'm just
I
looking
didn't
at
intend.
416 and 417.
Yeah, I didn't intend to make it any different, and I honestly don't believe that possessing a small amount of marijuana alone should disqualify people for you.
Then I would move
firearm.
we strike that line because I think it would be confusing to people.
That'd be a friendly amendment.
I'll make that motion.
Second.
Charles, you have that?
I do, Mr. Chairman.
All right. Can you report the amendment?
Mr. Chairman, the amendment on line 416 strikes a civil violation through this section on 417.
All right. That
It would-
motion, I'm sorry.
It would also need to strike on 418 or a civil violation or the subject of a civil penalty through 418 and 419.
Mr. Chairman, would it also, line 411, that whole section on 18.2-308.09, 339 through 311, does that need to be stricken too?
Mr. Chairman, that deals with,
Charles? Deals with what?
that deals with concealed handgun permits, so it's a different issue.
So it would impact the ability to get a concealed handgun permit with that language in it?
Yes, that's correct.
Mr. Chair,
Senator Peterson?
can we take up my amendment first because I think that's a separate issue, and then if we can get to the concealed carry issue.
All right. It's been moved and seconded to amend lines 416, 417, and 419, or 418 and 419 in the manner described by council. It's been moved and seconded. All in favor of that amendment signify by saying aye.
Aye.
All opposed, that amendment is made. All right, any other questions of the patron?
Yeah, Mr. Chairman, I have a question.
Senator Edwards.
I noticed you got forfeiture of driver's licenses. Do you really want to get involved in that? I have a friendly amendment to take all that out.
What line are you on, sir?
Well, it starts at 296, 18.2-259.1 through 338.
Yeah,
93.
well, we dealt with it last year, but what this deals with is, I thought that for a juvenile, that this would leave that in for a juvenile. Now, it says imposed for a criminal violation. This would no longer, the intent was just to leave it in for juveniles. Right now, you lose your driver's license unless you commit 100 hours of community service and the judge allows you to.
Yeah, Mr. Chairman, I'd like to ask.
Senator
count-
Edwards.
I'd like to ask count, is it only juveniles? Not the way I read it.
Mr. Chairman, it does provide on lines 305 to 307 discretion for the court to suspend for an adult violation.
Well, I did not intend it to be any different than current policy, so
I moved to strike that whole area because I don't think you're adding apples and oranges to this. It's a friendly amendment.
yeah, no, I don't want to make it any harder to have your driver's license. I was fine with leaving it in for kids, but I don't want to undo what we spent a lot of time last year doing and making better. So if this changes the current law, we want to get rid of it.
You know what? I suspect that if this reports out, you'll have a lot of opportunity to work on fine-tuning
Okay,
it.
so if we could, okay. I did want to make one more point about the bill, if I might.
Yes, go right ahead.
In terms of equal justice for marijuana defendants here in Virginia, I talked a little bit about the racial disparity, which is quite large. But I think this is important about the right to avail yourself of a strong legal defense. And some Commonwealth's attorneys do not prosecute misdemeanor possession. Others do, but in at least one circuit, marijuana possession defendants may not have access to a public defender. This is due to an agreement between the judges and the Commonwealth's attorney that they do not appoint public defenders in cases where the Commonwealth's attorney has waived the possibility of jail time. So if you're charged in that circuit, you don't get a public defendant to know what you can have, and others, you get someone to give you better advice.
Let's hear from people who'd like to speak in support of this bill.
Good morning, Mr. Chair.
Good
My name
morning.
is, and the members of the committee. My name is J.K. Davenport, Deputy Secretary of Public Safety and Homeland Security. The administration supports the decriminalization of possession of marijuana.
Okay.
Thank you.
Next.
Mr. Chairman, members of the committee, Claire Guthrie Gustiniag on behalf of the ACLU. As I mentioned before, we strongly support this bill over other options now before you.
Thank you. All right. Anybody wish to speak in opposition to the bill?
Mr. Chairman, ladies and gentlemen, Bob Sadler, Virginia Citizens Defense League. We intensely object to the concept of stripping the right to carry for a civil penalty. You all know how we bristle at the concept of taking rights for misdemeanors. Now we're going all the way to civil penalties. Please, why are we even having this discussion?
Thank you. Yes, sir.
Good morning, Mr. Chairman. David Ledbetter, Commonwealth's Attorney of Waynesboro, here for Virginia Association of Commonwealth's Attorneys. As I stated earlier, the Commonwealth's attorneys have taken a position is that we are opposed to the decriminalization of marijuana. We are split as to what course to change after that. Is it the status quo or just to remove it to a finable offense? But we are opposed to the decriminalization of marijuana for several reasons. First,
you're opposed to this bill.
We're opposed to this bill, which is decriminalizes marijuana and makes it a civil penalty for simple possession. The first issue is highway safety. In 2015, there were 35,000 fatalities on the nation's highways. 1/3 of those fatalities involved an impaired driver. In all the states that have either decriminalized or have legalized simple possession of marijuana have seen a rise in the use of impaired driving under marijuana. In 2013 and 14, the National Highway Traffic Safety Administration did a study of drivers at night. They found that 12.6%, or 1 in 8 drivers, had marijuana in their system. A similar study done in 2007 was a 48%. It was a 48% increase over the 2007 studies. And kind of surprisingly, they found in that 2013-14 study that marijuana was more common than alcohol in the system. All the states have seen a combination that have legalized or decriminalized it, that there is a combination of alcohol and marijuana's rise in their traffic cases. The prosecution of marijuana impaired driving is much more difficult than a prosecution of a alcohol and base because there's no per se cutoffs. There's not a limit like 0.08. In addition, all the testing requires a blood draw and would require a forensic toxicologist to testify because we don't have per se levels on those. So we would submit to decriminalize marijuana would be taking a step back in what's been 45 years of steady progress in highway safety. Second reason we oppose it is all the states that have either decriminalized it or legalized it have seen a rise in adolescent usage of marijuana. The studies have shown that the use of marijuana by adolescents on brain development, it is damaging. And in addition, the use of marijuana by adolescents has been shown to be a gateway drug, not for adults, but for adolescents. They're shown to be much more likely to go to the harder drugs. And the third and final problem we've seen in all the states that have either legalized it or decriminalized it have seen a rise in ingestion by pediatrics, because much of the marijuana is in the form of edibles, things of that nature. They've seen calls to the poison control centers, a significant increase of pediatric ingestion. So in conclusion, we can find little, if any, compelling reasons to decriminalize marijuana and many compelling reasons to oppose decriminalization.
Thank you, David. All right.
Mr. Chairman.
Senator Howe.
I'd like to move to report the bill as amended.
Mr. Chairman,
Is there a second?
first of all, I have a motion for amendment. And that is to delete lines 339 through 411 dealing with disqualification for concealed handgun permits for a civil penalty, which.
All right, is there a
it's
second to that
It's a friendly
motion?
amendment.
Is there a second to that motion? I'll second. It's been moved and seconded to delete the concealed handgun provisions, which I think would delete from the bill lines 339 through 411. Correct?
That's correct, Mr. Chairman.
All right, it's been moved and seconded. All in favor of that amendment signify by saying aye. Aye. All opposed. That amendment's made. Senator Howe.
Now, Mr. Chairman, I move to report as amended.
Is there a second to that motion?
Second.
It's been moved and seconded to, does this need to go to finance? No. To report as amended.
Mr. Chairman?
The clerk will open the roll.
Can I just make a point? First, I wanted to let the record show this one time that I agree strongly with the Virginia Citizens Defense League. That was not my intent. Further, the Commonwealth's attorney representative maintained that there were studies showing a variety of things. And I just wanted to quote from the National Academy of Sciences, which says there's little evidence that decriminalization is what we're talking about, not legalization, of marijuana use necessarily leads to a substantial increase in marijuana use. Further, studies of states, don't bother, just let take the vote.
I mean, we've already voted.
Oh, you already voted. What happened? Okay, we voted no. See, I was going to change all your minds with that closing comment. Thank you.
Well, thank you. And
Thank you, Mr. Chairman.
this is let me just say, you for the past couple of years have been a persuasive advocate on the issue. It's an issue that isn't going away. We're going to be talking about it for, I think, a long time, and I think you're advancing the debate. We spent a lot of time in the Crime Commission talking about this. Decriminalization was considered, a vote was not taken. We continue to look at it, and I just thank you for your advocacy and your provocative comments. So,
Well, thank
and I mean
you.
that in all sincerity and as a
Thank you,
compliment.
and thanks to the staff of the Crime Commission and for Senator Norman for raising it with the Crime Commission and his bringing it to the forefront as well.
All
Thank
right,
you.
thank you. Senator Favola.
Thank you, Mr. Chairman. I have a slightly different bill. What my bill does.
Senate Bill 40.
Yes, it is Senate Bill 40. And my bill deals with the penalties for possession with intent to sell or distribute marijuana. The current statute has very wide bans. And so what my bill does is rather than saying 1/2 of 1 ounce, it just says 1 ounce of marijuana is you would be guilty of a Class 1 misdemeanor. So I've increased the amount from 1/2 to 1 ounce. And then in more than 1 ounce, but not more than 1 pound of marijuana, you'd be guilty of a Class 6 felony. And more than 1 pound, but not more than 5 pounds of marijuana, you'd be guilty of a Class 5 felony. And more than 5 pounds of marijuana, you'd be guilty of a Class 4 felony. And the last thing I will point out is a language was added, and it says there shall be a rebuttable presumption that a person who possesses no more than 1 ounce of marijuana possesses it for personal use, which sort of reinforces the very first statement I made about the bill. This topic has come up several times in rehab and social services when we were talking about providing reentry programs for individuals who may have been convicted with, for possession of marijuana with the intent to sell. So I would hope that you would find my narrower bans more acceptable.
So, and can you give us some idea as to, I mean, how much marijuana an ounce is?
I'd need a scale to show you.
Well, can you?
I don't know. I mean, I could do my fingers if you want. How big a bag?
An ounce? That little, huh?
This would be an ounce.
I don't think that's right.
Mr. Chairman, my roommate told me one time.
I would need a
that it's-
scale, I guess, to tell you.
I withdraw the question.
I don't want to mislead the committee, Mr. Chairman, but that is a good question. I should have come with an ounce of something, but I didn't. I will just say the intent of this bill was to, help that teenage kid who, may have that more than a half an ounce and yet had no intention of possessing.
I would just say
possessing it,
that I've got some idea, and I would say a teenage kid with an ounce of pot in his bedroom, mom and dad got a problem. All right.
Well, the U.S. currently locks up more people for drug-related offenses than Europe does for all other offenses. I will just say that we need to look at this.
Yeah, and I agree. I'm not puritanical, but I do worry. You mentioned the teenage kids, and for me, I mean, that is my number one consideration is the impact on kids. If we've got adults who want to smoke pot, I'm a lot less concerned about it. But I am concerned about middle schoolers and high schoolers, and especially to the extent that this is intended to, create essentially 1 ounce safe harbor for high schoolers.
You'd still be guilty of a class 1 misdemeanor.
Okay.
So I'm not erasing the.
No, I
totally.
understand, and I'm just trying to share with you some of my concerns. Any questions for the patron? Anybody in the audience wish to speak in favor of this bill? Anybody in the audience wish to speak in opposition to the bill? The bill is before us. All right, there's a motion to report. Is there a second?
Second.
All right, it's been moved and seconded. The bill be reported. Clerk will open the roll.
Ayes 6, noes 9.
All right.
Thank you.
Thank you. And next, Senator Stanley has Senate Bill 33 at the request of the patron.
Yes, Mr. Chairman, members of the committee, Senate Bill 33 was to try to clean up any problems that Senator Evans and my bill that became law last year, which allowed for courts not to suspend licenses for first-time offenses under 18.2251, that we needed federal approval of that under the 1978 Highway Act that said that any conviction had to have a license suspension along with it. I believe it was through Senator McDougal's efforts that we got, word from the federal government that they did approve of Senator Evans and my bill, which became law, which meant we were in compliance with the federal government's requirements. What we were having was a problem. Some courts were enforcing the old law and some were doing it the new way. So that inequity has now been rectified and have been recognized that we don't need Senate Bill 33, so I'd move that it be struck.
All right, it's been moved and seconded. The bill be stricken. All in favor signify by saying aye. Aye. All opposed, that bill is stricken. Next, we have Senator Chase. Thank you for your patience. Whoop.
Thank you, Mr. Chairman and members of the committee. Looking at Senate Bill 911 pertaining to eminent domain and lost profits. This is a bill that I put in by request from the Family Foundation.
Don't say that.
Don't say that.
By request.
Yeah.
Well, go right ahead.
Being honest. Under the current law, if a property owner is left with even 1 square foot of land after a taking, he can claim lost profits for 3 years. But if the condemning authority takes all of the property, he's restricted to only claiming 1 year of lost profits. That doesn't make a lot of sense, in my opinion. That leads to serious inequitable outcomes, and because the condemning authority gets to decide if it is going to take all or only part of the property, it can create a perverse incentive to the authority to actually take more property than absolutely necessary in order to avoid having to provide compensation for the owner for 3 years of lost profits. This bill provides for the just compensation of 3 years lost profits for businesses that lose their property in whole, take eminent domain cases. Partial takes are compensated at 3 years. The law was silent on compensation for whole takes until 2015. And I'll just go back to the year 2015, whenever this body, the Senate, unanimously passed a bill. But because of a series of misunderstandings due to a drafting error, the House came back with a 1 year compensation limit. So the conference committee settled for the 1 year, and so that's what happened with the discrepancy there. I think it would have been better if the code silence had been maintained because at least then the courts had some discretion. Now they're locked into that 1 year. Condemning authorities have incentives to take whole properties, including slivers of land they don't need, in order to avoid paying the 3-year lost profit compensation. The bill simply evens the years of just compensation for hardworking business owners who lose their entire land because of eminent domain with those who lose only a partial taking. It is fair and the right thing to do. 1 year of lost profit compensation simply isn't enough.
All right. Anybody have any questions of the patron? Senator Peterson?
First of all, I want to thank the patron. I have a bill, Senate Bill 809, which deals in the exact same subject matter. It's a little bit broader. So I don't know if you wanted me to present it now or wait or whatever you want.
Have you looked at Senator Peterson's bill?
I have not looked at his bill yet, but I would check with those that asked me to request.
I tell you what, let's, before we vote on yours, let's hear comments from folks in support of and in opposition, and ask them to comment on the two approaches, and we may take these up at the same time.
Perfect.
So,
Sounds good.
Chap, you want to just real briefly explain the difference between yours and Senator Chase's bill?
Yours is just the 3 years. Okay. Thank you, Mr. Chair, members of the committee. Mine is Senate Bill 809, and I agree with everything my colleague just said on the 3-year discrepancy. Right now, if it's a whole take, you only get 1 year of lost profits if your business is impacted, while if it's a partial take, you get 3 years. And there's really no reason for the distinction of which I'm aware. Now, I do not a fair amount, I do some of this work, and here's the reality. Oftentimes, the business owner and the landowner are separate people. The landowner right now is entitled to just compensation under both the Constitution and under statute. And under statute, and the Virginia Supreme Court has recognized the right of business loss, and that's also been embedded into our Constitution. What often happens is you'll have a business owner that will have a lease on the land, and their business will be impacted and oftentimes closed because of the taking. And under the lease that they have, the commercial lease, the leasehold interest is given to the landowner. So they may have purchased a business for several $100,000, of which they lose the business.
Yeah, I think everybody gets the concept of lost profits.
Right.
And so how's yours different
Okay, here's how
from
mine is different.
Amanda's bill?
I have two differences which I think are material. One
And you
is
still have to prove that you've lost the profits.
Oh, absolutely. You got
All
to
right.
come in with an expert, and typically you'd have to get some type of legal help. Two things I have that are different. One is I actually, in the back part of my bill, I give a mechanism whereby you can intervene in a proceeding, because right now the notices actually go to the landowner. So as the business owner, if you have a lease and you're not the owner of the land, you need a mechanism which you can intervene in the proceeding. So the second thing is the date by which you can claim your lost profits. The date when the certificate of take is filed is often date when the construction begins. And so this would allow you to use the later date when the construction begins as the date when the lost profits actually accrue. So I do have one expert witness I brought down from Northern Virginia.
Mr. Chairman, I have
Senator
one question
Stanley.
of the patron.
Yes, sir.
So if the pipeline is coming for your land, or VDOT is coming for your land, and I hire an eminent domain specialist,
That's right.
you're saying my recovery will be larger?
Well,
If I prove my case.
It really depends on the quality of your attorney, but I can't help with that. So.
Well, and whether you have any profits and can
And well,
prove them.
you got to have profits, and I would tell people, you're going to have to show your tax returns that you've actually had a profit, or else you're not going to have a claim period.
You know any farmers who make a profit?
You know what? I don't have as many farmers.
I withdraw the question.
Mr. Chairman, I have a question.
All right, so, let's hear from.
Well, I have a question to the patron, just
All right.
to clarify. Is the main difference between yours and Senator Chase's bill that there's no time frame?
No.
Is that the main difference?
Well, one, I have the intervention mechanism, and two, yes, I do change the date of the timing.
But
Mine's broader.
But hers.
But you still have a 3-year limit.
I have the 3 and 3, yeah.
Right.
Okay.
All right, let's hear from your witness real briefly. And this would be the time for people in support of either of these bills to step up.
Mr. Chairman, member of the committee, my name is Michael Coughlin. I am an eminent domain attorney. Thanks for calling me an expert. The reason for adjusting the time frame for which you calculate lost profits is as follows. We had a case in Stafford County, certificate of take filed in 2013, and the construction didn't begin until 2016. And so under the current law, because you use the tax returns from the prior 3 years to calculate your profits, no profits had been lost because nothing changed on the ground. And so as a result, our client had no lost profit claim to make under the existing law. This changes that. This would then allow, if construction for whatever reason is delayed, for the date of the start of the construction to be the time period for which you'd be able to calculate lost profits. I'm certainly in favor of having parity in terms of the 3 years. I do think that under the existing law, it's confusing and silent as to when you would intervene or how you would intervene in these cases. So we believe that that's an important addition that's needed. Chap referenced that. That's in lines 125. And then in addition, we think that it's also valuable to have a mechanism by which you'd be able to bifurcate the lost profit case from the underlying traditional real estate just compensation case.
Okay.
Thank you.
Thank you. Next, step right up. And I believe that Senator Peterson's bill is the broader of the two bills, and it does incorporate everything that Senator Chase has in her bill. So what I'd like to know is, A, do you support it and why? Don't go anywhere, Steve. And do you, for some reason or another, support the narrow approach or the broad approach?
Thank you, Mr. Chairman. My name is Steve Rossi. I represent the Family Foundation of Virginia. And we do support both bills, but I think we've come to an agreement where we prefer Senator Peterson's broader approach a little more, and that I think Senator Chase would be willing to roll hers in.
Super.
And also, Nicole can't be here, so she asked me to speak for NFIB. NFIB also supports Senator Peterson.
All right, thank you.
Thank you.
Yes, sir.
Mr. Chairman, members of the committee, Paul Howe, Virginia Forestry Association. We agree. We think the broader approach is probably the way to go. I apologize to Senator Chase for not having a chance to speak to her about that, but we're supportive.
Okay.
Mr. Chairman, members of the committee, I'm Andrew Smith, Virginia Farm Bureau Federation, and we do support the broader approach.
All right, thank you. Okay. Those who'd like to express concerns about either of the bills, step right up. Roger.
Senator, I think I see how things are moving here. I would just say that on behalf of VML and VACO that I understand the kind of drafting error that led to this kind of imbalance between full takes and partial takes. And I don't have any problem with evening that out. I think what we would prefer, though, would be if the court were given the authority to award damages for up to 3 years, because I think there could well be cases in which the full 3 years wouldn't be appropriate. The example that was suggested to me was a video rental business, which may well have made a profit 3 years ago, but is unlikely to be making a profit 3 years hence. I think there are probably other examples like that, and so I don't think we would have too much problem with giving the court discretion.
Isn't that something that your expert would testify to?
Possibly.
Okay.
Possibly, but I still would feel better having the court have some discretion over.
Okay.
The other thing is that we feel like obviously this is going to have an impact on VDOT projects, and that for that reason it ought to go to finance.
And it will.
Okay.
Mr. Chair.
Senator Deeds.
Mr. Chair, I'm just looking down at line 35, and it says not to exceed 3 years. Isn't that the discretion that you talk? talking about?
It does say that? Okay, I'm sorry then.
All
I
right.
missed that point, so I think we're okay with that. Thank you.
Okay. Chris?
Morning, Mr. Chairman. I'm
Fairfax.
Chris Costa with Fairfax County. We don't have any position on Senator Chase's bill. Our board doesn't have an objection to equalizing the 3 years in either of the bills. The only problem is our staff trying to wrap their head around this whole valuation process and the fact that so we have not had in our recent staff experience any cases go to court. So this may in fact not, we end up settling everything and coming to agreement.
You mean
So
the sky
hopefully this
has
won't-
not fallen?
Right, yeah,
Thank
surprise,
God.
right? No. So at any rate, my point is that to the extent that we keep that streak going, we're great, and this bill will not affect us. But the problem is if we do end up going to court, you'll have a case where someone where we file a quick take or a slow take condemnation. You'll get to a panel verdict, but then you'll have this bifurcated proceeding, so we will not be able to just provide compensation to the landowner all at one time. It'll delay that compensation for that landowner to some extent. We'd like to be able to just wrap it all up neatly in a bow, if you will, once, and then also be able to plan our budgeting and our projects accordingly, because often we do land acquisition prior to continuing construction because we think that's good management, that's good government.
Right. Okay.
Thank you.
Thank you. All right. The bills are before us.
Mr. Chairman, I move that Senator Chase's bill be rolled into Senator Peterson's bill.
Well, I think that,
Yeah, it was both of them be listed as chief patrons.
yeah. Is that okay?
That's fine.
All right, we're gonna, with that motion, is there a second?
Second.
It's been moved and seconded. Clerk will open the roll, and re-refer to finance is the motion. Yeah. Can you open the roll? All right, well done. Thank you. Senator. Yeah, why don't we do that real quick, and with apologies to the patrons who are here.
And I only say that because we
You
kind
do.
of opened up the knowledge base. This is Senate Bill 278. If I have a substitute to distribute, please.
All right, there's motion properly seconded to adopt a substitute. All in favor signify by saying aye. All opposed. That substitute is before us. Senator Peterson, I believe that this bill is pretty simple. It simply requires local governments or condemnors to pay promptly.
Right.
And you set a 30-day time
30
limit.
days.
All right. Anybody have any questions about the bill? Hearing none, anybody wish to speak in favor of the bill? Anybody wish to speak in opposition? Yes, sir. Step up.
Favor?
Go right ahead.
Steve Rossi, Family Foundation, we support. And belatedly thank Senator Peterson and Senator Chase for bringing the previous bills. I forgot to thank them publicly. Thank you.
Thank you.
Mr. Chairman, Paul Howe, Virginia Forestry Association, we are in support. Thank you.
Michael Coughlin, eminent domain practitioner. I'm in support of this bill. This is a real issue of a delay in payment by localities and VDOT. Thank you.
Whoa. Don't go anywhere. So they delay payment. I used to say, 6.5% was pretty good return. I'm not so sure it's pretty good return anymore, at least not right now. You get that statutory interest, right?
Nope.
You do not. Pardon me?
No, you're stuck with the settlement terms.
Oh, okay.
So there could be a settlement, and then
I
it
see.
could just take a
All
while
right.
for it to get
Gotcha.
processed. I don't think it's an intentional thing on their part. It just happens, and there's nothing prompting them. This would prompt them.
Okay. Well, don't you put that in your settlement agreements?
If they
Paid
fight
within
it,
30
they fight it
days?
tooth and nail, it just arbitrarily.
Can I speak to this, Mr. Chair?
Hang on, let's go through that, and I'm sorry. All right, let's go through the process, and you can in a second. All right, thank you.
Sure.
Andrew Smith, Virginia Farm Bureau, we support the bill.
Nice tie, by the way.
Mr. Chairman, VML and VACO don't oppose the prompt payment provision, but we did give Senator Peterson some language to make it clear that the settlement attorney would have responsibility for seeing that all the lien holders were satisfied before payment was made to the landowner.
Is that in the substitute? I don't think so.
It is not. And I had a piece of paper that was drawn to the original bill, not to the substitute, so that line numbers may not be correct, but.
I had no objection to it.
Have you given that to council? Committee council?
I basically reported as saying that the landowners council will be responsible for making sure that all liens on the property are satisfied from the proceeds.
You have language?
I can provide some language if I see this, where it goes in the substitute, yes. I had language written down, I don't know if
And with
Senator
that, you're
Peterson
okay
still
with
has it
this?
or not. Yes.
Okay. I tell you what. I tell you what, let's suspend and we'll come back to
Thank
this shortly.
Thank you.
All right. Senator Norman has Finance Committee commitment. He's got one bill. Sorry, Dick.
Thank you very much, Mr. Chairman, and I apologize to my colleagues. I need to go to the Finance Committee meeting, but Senate Bill 846, which is a restitution bill. This is a bill that was brought to my attention by my good friend Randy Carter, who is here, who is clerk of the Suffolk Circuit Court. What they are finding is that when restitution is ordered, when individuals are sentenced to anything over 20 years, that under the statutory provisions, the restitution judgment is unenforceable. And so what they are seeking to do is to extend that. And Mr. Carter is here to speak very briefly.
Yes, sir.
Yes, sir.
Welcome. And
good morning, Mr. Chairman.
Name and position?
Randy Carter, clerk of the Circuit Court of the City of Suffolk.
Well, welcome.
Not a week doesn't go by that someone doesn't come in and says, my judgment's more than 20 years old. And he's right. And there is no practical way I can enforce this anymore. They may be off of supervision, supervised release, whatever, and the judge is more than 20 years old. It's out there, and I will tell you, my accounts receivable right now is $12 million. And most of that is uncollectible judgments.
All right. Well, give our regards to Mr. Ferguson, okay?
I have a question. Does interest run on this?
Pardon me, sir?
Does interest run on the judgment?
Not while they're incarcerated, sir. Only once they're released from incarceration does interest kick in, sir.
And Mr. Chairman, what's the
Senator
problem with
Edwards.
20 years, though? That's a long time.
Well, some
Problem
people
with
spend more than 20 years in prison.
If a person, let's say, gets 25 years active time in the penitentiary, he doesn't get paroled to sometime or released sometime after 20 years. That judgment, just give you, now to get the weeds, that person goes to court, he gets sentenced. One of my deputy clerks the next morning enters the fines, costs, restitution into the system. The next day, the printer pours out, here comes the judgment, we send it over to land records, this document. So 2 days after he's sentenced, that clock has in essence started to tick.
So, Mr. Chairman, so you don't want any statute of limitations?
I think the bill, if I remember correctly, has a 60-year statute of limitations on fines and costs. And I think the portion for restitution has no statute of limitations. Is that
Mr.
correct?
Chairman, so
Senator Edwards.
if somebody gets out after 5 years, you got 60 years, and interest continues to accrue for that whole period of time? Don't you think the person who's getting the benefit of the restitution should have some obligation to do something?
You mean the victim of the crime?
Yeah, the victim of the crime, to do something.
The victim of the crime may be multifold. I mean, you may have insurance companies, you may have individual victims. For example, the insurance company kicks in, they pay the deductible, so there's a bifurcated.
There's another question, Mr. Chairman, and that
Senator
is
Edwards.
the obligation of the prosecutor. Most prosecutors don't do a darn thing about these restitution orders. Isn't that right?
I can't speak for prosecutor. I was one for 17 years, but I can't speak for them.
I can assure you they don't.
So let me ask you this question. I
Yes,
mean,
sir.
the criminal defendant at the time of sentencing is made aware of his or her restitution obligations. Are they
Yes, sir.
not?
Yes, sir, because the way it works is that I know there's a bill out here for part-timers later on, but right now the Commonwealth's attorney will bring in a restitution worksheet which shows how much is owed and to which party it's owed to.
So to
And that's
Senator
part of the
Edwards' question. The real question is, who has the obligation? Is it the Commonwealth attorney or the criminal defendant? Should the criminal defendant who owes the restitution to the victim have some affirmative obligation to actually fulfill that obligation? Right?
Right.
Thank you. Any other questions?
Very quickly.
Senator Norman.
Only because Senator Edwards raised the issue. Nate, where'd you go?
Good morning. Nathan Green, Commonwealth Attorney for Williamsburg, James City County. I'm speaking on behalf of Virginia Association of Commonwealth Attorneys offices. We are in support of this bill, and I do think it's victim friendly.
All right. All right. Anybody in opposition to the bill? The bill is before us. There's a motion properly seconded to report the bill. Clerk will open the roll.
Thank you very much, Mr. Chairman.
All right. Thank you. Senator Black.
There's a laches issue, too.
Thank you, Mr. Chairman. This is Senate Bill 186. I wish I could tell you that I'm bringing before you an earth-shaking measure that will revise the law of the Commonwealth, and I suppose this does revise the law in a tiny way. But basically what we've got under the law dealing with the use of unmanned aircraft drones, there is a provision that begins on line 29, section D, and it spells out the fact that drones can be used for non-law enforcement purposes, and that doesn't trigger any warrant requirement.
Dick, let me, if I could just put, and this may be really simple, maybe, may not be, but my understanding is that there are already permissible uses for drones for non-law enforcement purposes for state agencies, and this simply extends the same authority to localities.
That's exactly right.
All right. Can we just see if does anybody have any questions? Anybody in the audience wish to speak in favor of or in opposition to this bill? All right. It's been moved and seconded to report this fine bill. Clerk will open the roll.
This is a tough committee.
Congratulations. We try to help. Try to help get the right result. All right. Senator Suravel.
Thank you, Mr. Chairman.
You only have 3 bills today.
Only 3.
That's awesome.
Happy to oblige.
Senate Bill 608.
Yeah, I think 608 is probably the easiest, or the quickest.
I think it is too.
So 608 is basically it basically says that no Commonwealth attorney can condition a plea agreement upon waiver of expungement, and it's not directed at SIS situations, continuance for dismissals where you stipulate you're guilty, but the situation is that there's at least one Commonwealth attorney in Northern Virginia, I don't know about the rest of the state, who will only null pros or drop a case if you agree not to expunge it in some situations. And it seems to me if there's no case and you're innocent, that you ought to be able to get an expungement. And so that basically is what it says. I mean, under existing law, if you plead guilty to an offense or plead guilty to an alternate offense, there's expungement law works the way it works.
Senator Norman.
Senator Suravel, is this a one-judge issue, or have you found?
It's a one prosecutor issue. I don't know if there's other prosecutors in the state that do it, but there's one Commonwealth attorney in Northern Virginia that, for example, in drunken publics, won't drop a drunken public unless you agree not to expunge it. So, they make you go to trial if you want to actually go for your expungement.
I just would say, Mr. Chairman, I do a little bit of this area of the law, and it's the first time I've ever heard of this.
I mean, isn't it? I mean, it's constitutional for a Commonwealth's attorney to ask for that, isn't it?
They're allowed to ask for it. I just don't think they should be able to. To me, it's kind of against public policy.
Isn't it your choice as to whether to agree to that on behalf or with
Sure.
your client?
Sure, but in Northern Virginia, you get a lot of folks with security clearances, and having their record clean is really important. Even something like a drunken public or a minor misdemeanor is a big deal to them. And so, it's important to try and keep the record clean, and this just gets in the way of working out a deal when they take that position.
I mean, aren't you legislatively trying to get a better deal here?
Not really. I mean, if there's no evidence, you can't prove your case, or somebody ought to be acquitted of something, it seems to me you ought to have your right to an expungement.
Or an acquittal?
Yeah, sure. Then you have to go to trial, and then you end up spending an extra 4 hours in court and rolling those dice, and, this expungement thing gets in the way of a lot of discussions.
All right, any other questions to the patron? Anybody wish to speak in favor of or in opposition to this bill?
Move
Bill is
report. Move report. Good bill.
Commonwealth, hang on, Commonwealth's attorneys, I'd like to hear what they have to say.
Good morning, Mr. Chairman. David Ledbetter, Commonwealth's attorney of Waynesboro. I'm here on behalf of the Virginia Association of Commonwealth's Attorneys, and we are opposed to this bill. Very oftentimes, we'll use an expungement as part of a plea agreement where we'll drop some charges for convictions on others, and we do set as a requirement for that those that are dropped are not expunged, where they're not innocent of the charges, but we've chosen as part of the plea negotiation process. In addition, we'll often also use the non-expungement. We'll take a charge for an individual, say a young person that has no prior record. We will defer that charge out or continue it for a year. They're truly guilty of it, but we'll defer it for a year and then have them be found not guilty. We would submit that they should not be able to expunge that as part of that agreement.
All right, thank you.
Mr. Chairman.
Senator Reeves.
I just wanted to ask Mr. Benjamin, because I know he does extensive work, what his experience is.
Mr. Chairman, if the question is whether we do occasionally see these types of provisions in plea agreements, the answer is yes.
Mr. Chairman.
Senator Stanley.
Just to follow up, though, Mr. Benjamin, I heard from the Commonwealth attorney talking about how that they drop some charges which they may be guilty of, and this would prevent that. I mean, isn't there a hearing process on an expungement one way or the other if the Commonwealth objects? If there was a null pros, and let's say I filed on behalf of a client an expungement, that they can go in there and say that that person was really guilty, they just chose not to prosecute, and that would prevent
Mr.
the
Chairman,
expungement.
Senator Stanley, I think that with misdemeanors, it is virtually automatic. You still have to have an expungement petition filed, but you have a right to expungement if a misdemeanor has been null pros or dismissed.
If you don't have a prior record.
So this would apply to, for example, a rape charge pled down to a misdemeanor in which the misdemeanor or the Commonwealth's attorney agrees to a misdemeanor on the condition that it will not be expunged.
No.
Mr. Chairman, no, that's not correct, because you can never expunge a conviction.
Oh, I see. Okay, I got you. Never mind.
Or if it's a lesser included.
Mr. Chairman, Senator Stanley, Reeves makes a good point that it is very often the case that an individual will be charged with multiple offenses, and as a trade-off for a guilty plea to one, a number of charges will be null pros. If the practice becomes more prevalent that plea agreements will include this requirement, then you're going to sweep in those offenses that should not have been charged.
Mr. Chairman.
It could be abused, in other words.
Mr. Chairman.
How about that case in which, to put it in proper context, rape case, prosecutor, police are dead positive they got the guy, but for some reason they drop the charge, they can't get a conviction, and they go, hey, we're gonna make a deal, but not because we want to, but we will not, under any circumstance, agree to any expungement. So this would prevent that.
Well,
Mr. Chairman. Mr. Chairman, because if a felony is null pros, then there must be a hearing at which you show that it creates a manifest injustice. And so there would be a substantive hearing before a circuit court judge.
All right.
Yeah,
Okay.
Yeah, Mr. Chairman.
Sarah Edwards.
I was going to point out that you got to show, one, you're found not guilty or dismissed, and two, certainly with a felony, that it affects your employability in some way, something like that.
All right.
Right.
All right, the bill's before us. It's been moved and seconded the bill be reported. Clerk will open the roll.
Ayes 9, no 6.
All right, that bill's reported.
Thank you, Mr. Chairman. I don't know which of the next two is the quickest or how you
It
want to do
doesn't
this.
matter. Let's go 608.
Okay. We just did 608.
I'm sorry, let's do 607.
Okay, so 607 was the bill you all heard last week, which is similar to Senator Stanley's bill. And we talked about potentially putting the two together. I prepared a substitute.
All
I
right,
did
we've
that.
got a substitute, I believe. Senator Stanley moves, Senator Stewart seconds the adoption of the substitute. All in favor signify by saying aye. All opposed, substitutes before us.
And Mr. Chairman, I believe that this was rolled last time. His bill was rolled into mine with Chief Kopak.
Yes.
It was on 168.
All right, and tell us what your substitute does.
So the differences between my substitute and the two bills before is the substitute is basically Senator Stanley's bill, but it adds possession, the possession language from my bill. This has to do with sexting. So Stanley's bill only had to do with transmission. Mine makes possession of 10 images or less of a juvenile, a misdemeanor. That's number one. Number two, it adds, in addition to what was not in my bill or Stanley's, which is now in both, is it adds a malice requirement. So that if the transmission of the nude image is done with malice, it stays in the felony world. So this is only consensual transmissions between kids or a child in possession of another child's, of less than 10 images of another child, again, without malice. And that's basically the changes in the combination bill.
Were there further changes that were talked about, or am I misremembering?
I don't think so.
We have possession.
Yeah, right. We added possession, malice, and I think that's it. Stanley's venue provision was a little bit different than mine. I think mine said venue was where it was either sent or received, and Stanley's bill is venue is where the original, the child who's in the image lives.
All right. All right. Peace?
Oh, yeah.
Huh?
We're good.
All right.
We're always good.
Steve?
I wonder, I understand what the patron is doing, Mr. Chairman, on line 17 with the requirement that it be without malice, but I might suggest that we use tighter language to capture the category of offenses that the patron might envision. And so it might say that it's a misdemeanor if the dissemination is done without intent to harass, intimidate, or extort money or pecuniary benefit.
That's fine. You're
Friendly
starting to get
amendment?
into, I think so. You're starting to get into the revenge porn area there, which we already have a statute on, but.
Let me make this point, Mr. Chairman. If heat of passion negates maliciousness, and so if you have an X situation and somebody sends naked photos out of revenge, then they would not be acting maliciously.
Right.
But there would be an intent to injure or harass.
Right. Yeah, that's fine.
Okay. Is there a motion to that effect?
So moved.
It's been moved and seconded to adopt Steve's amendment. All in favor signify by saying aye. Aye. All opposed? All right.
Mr. Chairman, one other point.
Yes, sir.
On line 19, the bill includes the body parts. If you send an image of that body part, it's a crime. And I'm wondering if buttocks should remain in there because of the prevalence of swimwear, for example, that nevertheless displays that area. That's a policy question for you, but I could see where it'd be problematic.
Would you
What beach are you
comment
going to?
further?
Yeah.
No, just kidding.
That's it.
Mr. Benjamin, what beach are you going to, buddy? I mean,
Virginia.
Thanks for that.
No, thank you.
All right, anybody wish to speak in favor of this bill?
Can we ask some?
I'm sorry, Senator McDougal.
Mr. Chairman, before we get to that, I had a couple questions, and maybe Steve can help with this too. On lines 23, it says obtained with the consent of the depicted minor. isn't it below a certain age that we deem minors don't have the ability to consent?
7?
No consent, 4, 7 is
Oh,
rebuttal.
contributory
That's right,
negligence.
yeah, that's right.
It's 4 and 7, isn't it? No consent, 4. You can change it to rebuttable, 7.
Well,
Well, Mr. Chairman, I have a, it
don't
does.
we want to keep that, I mean, if it's below an age that a child is able to give consent,
Right.
don't we want to
That's 4.
keep that?
Mr. Chairman, that's going to dovetail in, or bring that up into my second question, because right now, if I'm reading this correctly, and I'm asking if y'all agree it reads this way, if you have a 17-year-old that obtains a picture of a 8-year-old, then we would say that that's now a misdemeanor.
Yep. Mr. Chairman, if I may address that, Senator McDougal, if you go to line 39, that takes care of that provision. It allows for the discretion of the prosecutor who looks at the facts to say, this doesn't prevent me from not charging a felony in those type of circumstances.
Right.
So that is really a release gap there that would keep that from occurring with that safety valve. Yeah, release gap.
Senator McDougal.
Mr. Chairman, and while Mr. Benjamin is still cogitating on that consent language, one other question. Can you tell me, I mean, I know conceptually we all have this concern about children in consensual circumstances being prosecuted for possessing or sending these types of images. Do you know how many prosecutions there have been in Virginia in the last 5 years for this? Because I guess one of the concerns I have is what you just said. Now there's a second way, so prosecutors are going to start charging more offenses because right now it's a felony.
Mr. Chairman, I'd answer the gentleman by saying, while I do not know the number, because I guess, you know, in statistics which may be compiled or kept, I don't think they categorize it in that way of in those cases where a felony was charged, it was because two minors passed pictures between each other. But I can say this, we had this case in Franklin County, we've had this in Pittsylvania County with high school students who were then branded with a felony and a major felony, and there were prosecutors who were handcuffed and not had the ability to look at the situation and determine whether this was this case or that case, a felony or a misdemeanor. And so what this tries to do is address when those things happen, because, Mr. Chairman, Senator McDougal, you and I are the father of daughters, and this scares and Senator Surville, this scares the heck out of us. But this is happening more and more, and we need to address it in this way.
Any other questions? All right, those who would like to speak in favor of the bill?
Wes Nance, everybody.
Mr. Chairman, members of the committee, my name is Wes Nance. I'm Bedford Commonwealth's attorney, speaking on behalf of the Virginia Association of Commonwealth's Attorneys, and we are in support of this bill. It gives prosecutors the ability to rehabilitate juveniles who are often self-victimizing themselves by use of a misdemeanor as opposed to a felony. We had the same concerns as Senator McDougal, but we do believe that subsection F on line 39 does allow us the discretion to prosecute felonies when appropriate, whether it's through the acts of malice, force, threat, or intimidation, or if you have the large age gap in which you were specifically referencing. So we are in support of this bill.
Thanks, Wes. Good to see you.
Yes, sir. Thank
Appreciate you being here. Anybody else wish to speak in favor of this bill? Anybody wish to speak in opposition to this bill?
Mr. Chairman, members of the committee, Claire Guthrie-Gastanaga on behalf of the ACLU of Virginia. We have opposed this bill every time that it's been put before you. The rationale always is that it's important to create a new offense that will allow prosecutors to bring something other than a felony pornography charge against teens. Aside from the numerous problems that arise when creating any new criminal offense, there are reasons why most Virginians are incensed when they hear about kids getting prosecuted for what is essentially dumb behavior. It's dumb behavior, it's risky behavior for two teenagers to send this kind of stuff back and forth to each other. It's clearly a poor decision, it's bad judgment, but we shouldn't be dragging kids into court every time they do something that's stupid. I mean, think about this. The Supreme Court's recognized that children generally are less mature and less responsible than adults. They often lack the experience, perspective, and judgment to recognize and avoid bad choices, and they're more vulnerable and susceptible to outside pressures. Consider that a Class 1 misdemeanor still is potentially a year in some kind of incarceration and potentially registration as a sex offender. It's not, just a little thing. I mean, right now, Commonwealth's attorneys who exercise good judgment and common sense do not charge kids who exchange these kinds of pictures with a felony.
Claire, can't they still, if this is adopted, still exercise that common sense and not charge this?
But the reality is that, look, if it's the case that Senator McDougal is positing, where you have an 18-year-old or 17-year-old and they're taking pictures of 5-year-olds and 6-year-olds, then we ought to be looking at that child's behavior very seriously and addressing it seriously. But if I send pictures of my parts to my boyfriend, it should not be a criminal act. It shouldn't be defined in the code as a criminal act, and it shouldn't be prosecuted as a criminal act.
And your boyfriend sends it to his friends.
Well, I mean, again, it's stupid that I sent that picture in the first place. But, to my mind,
Okay.
this is digital.
Okay.
This is the equivalent of digital mooning,
No.
okay?
Mr. Chairman.
And we didn't prosecute kids and put them on the sex offender registry list
Mr.
for
Chairman.
mooning
Senator
each other.
Edwards.
Yeah, first of all, isn't it a First Amendment right for adults to send whatever they want to back and forth? And secondly, isn't it a fact that it's already against the law to do this? You're just giving the prosecutor something less than the stiffer charges.
Mr. Chairman, Senator Edwards, I believe that teenagers have constitutional rights too, and I do believe that a teen who sends a picture of himself or herself to someone else has First Amendment rights to do that. But I also think that this is an invitation to prosecute, criminalize, and put kids on the sex offender registry who should never be considered to have committed a criminal act in the first place. I mean, we need to be dealing with it in schools, in our living rooms, in our churches, not in our courts and in our jails.
Thank you, Claire.
Mr. Chairman,
Senator Peake.
I guess this would go to the patrons. If this is a sex
That's
offense.
fine. Let's, hang on, time out,
Yeah.
just a second. Anybody else wish to speak in opposition to this bill? All right, Senator Peake, go ahead.
Yeah, can we make this so it is not, if it's a misdemeanor, a sex offense registry? Is it?
We don't think it is.
It is not, correct?
It's not.
Mr. Benjamin, okay, thank you.
All right. The bill is before us.
Mr. Chairman?
And this needs to go to finance, is that right? No? Okay.
Mr. Chairman, I have one, if I may. It looks like when we put our two bills together, there is some inconsistency, Mr. Benjamin. Subsection is B is a Class 1 misdemeanor. Subsection C is a Class 2 misdemeanor. I mean, is that?
That was a mistake.
Inconsistent, but
My bill was a 2, his was a 1, and when I put them together, I forgot that.
Greg's.
Mr. Chairman, I don't think it's an inconsistency. One is a transmission and the other is a possession. And typically, we punish transmissions more harshly than possessions.
So we meant to do it
You
that
meant
way.
to do it.
Okay, thanks.
Mr. Chairman?
All right, Senator McDougal.
I very much respect what Senator Serval and Senator Stanley are trying to do. I still have some pretty big concerns. One of the ones is we're talking through process. If there's a felony, an individual has to go to a law enforcement officer or a Commonwealth's attorney to get an indictment or warrant. If we make this a misdemeanor, then a juvenile or a juvenile's parents can go directly to a magistrate and get a warrant out for an individual. They cannot. No, can't go get it with felony. So, Mr. Chairman, I understand what they're trying to do, and I think that this is clearly a lot better than previous versions that we've seen, but I still do think that there's some potential significant negative pitfalls out there if we pass this.
All right. Bill is before us. Substitute, as amended.
Move to report.
It's been moved and seconded the bill be reported. substitute as amended. Clerk will open the roll. All right. Substitutes reported.
Ayes 11, noes 3, abstentions 1.
All right, next, I'm going to take the prerogative of taking up Senate Bill 565 next.
Sorry. Oh. Not yet. Wait.
Mr. Chairman.
Senate Bill 565.
Members of the committee, Senate Bill 565 is a crime commission bill. This bill emerged from really the tragic circumstances involving two murders of college girls in Charlottesville. Hannah Graham, Morgan Harrington, as you will remember, their murderer was somebody who would have been caught before he committed these murders had we been collecting DNA evidence, which is collected by a swab on the inside of the cheek upon certain misdemeanor convictions. This murderer was convicted of criminal trespass before committing a number of other crimes. He was also subsequently convicted of a subsequent event in Fairfax in which he committed a violent sexual assault. The victim of that sexual assault escaped miraculously with her life, but also escaped with some of her attacker's DNA under her fingernails. And had he given a swab of his DNA following his misdemeanor conviction, he would have been caught immediately following the testing of that DNA from under the fingernails of the victim of his violent sexual assault. A couple of years ago, in 2015, we passed legislation that created a requirement that people who commit certain misdemeanors give DNA following their conviction. This is not a pre-conviction requirement. It is a post-conviction requirement. And the Crime Commission was extremely helpful in 2015 in narrowing the number of crimes to which this requirement would attach. And they went through a methodology in which they looked at misdemeanors that were predictive of violent, felonious behavior. And we created a list based on that quantitative research. Over the past 3 years, we have had 3 years of experience in trying to figure out whether this is effective. And Crime Commission is here, and I'll let Colin briefly address the effectiveness. And it has yielded a tremendous number of hits. Now, remember, this is not simply helpful in obtaining convictions. It is also a critical piece of information used to exonerate people in connection with accusations that they committed crimes as well. And we have used those 3 years of experience to look at whether we got it right and whether the list is a list that is going to achieve the purpose that we set out to achieve. And the Crime Commission updated its quantitative research and went through and concluded that there are additional misdemeanors that should be included in this list that will yield those benefits. And as a matter of fact, when we passed the legislation back in 2015, one of the categories that was left off and one of the misdemeanors that was not included was criminal trespass. So it would not, as passed, have captured the data necessary to keep this murderer off the streets. This bill does go back and add that, not just simply sweeping in broad categories of misdemeanors, but because criminal trespass, assault and battery, domestic assault and battery, and the other crimes listed on this list are predictive of the likelihood that the criminal defendant will, in all likelihood, or statistically is likely to commit a violent criminal offense. Now, it's important to remember that virtually every crime that's on this list, virtually every crime on this list already requires a fingerprint. It is a minimally intrusive test, collecting the DNA, and appropriate safeguards are made, I believe, to prevent and make sure that it is not used to get a conviction, and I don't see how it could get a conviction of somebody who did not commit an offense. This is a quantitative study, and I respectfully submit that these additional crimes belong on this list for the collection of DNA. Now, Mr. Chairman, members of the committee, I've got a couple of witnesses and would ask you to take a minute and listen to testimony of the Harringtons who are here to testify, the Grahams who are here to testify about their experience, as well as the Sheriff of Albemarle County, Chip Harding, and Commonwealth's Attorney of Albemarle County, Mr. Tracy. So with that.
Yes, y'all please come up.
Good morning. Susan Graham, mother of Hannah Graham, who was murdered by Jesse Matthew in September 2014. I'm sure you're very familiar with what happened then. Briefly, Jesse Matthew abducted and murdered Hannah. When his DNA was tested following his arrest in connection with Hannah's disappearance, he was linked to the other heinous crimes that have already been mentioned, the brutal sexual assault and attempted murder in Fairfax City in 2005, and the abduction and murder of Morden Harrington in Charlottesville in 2009. Now, Jesse Matthew was convicted of criminal trespass in 2010. If his DNA had been tested after his conviction for that offence, he would have immediately have been connected to the previous heinous crimes, and he would have been in jail in September 2014. Hannah would never have had the misfortune of encountering him in Charlottesville. He wouldn't have abducted and murdered her, and she would be alive today. This proposal will hold perpetrators accountable. It will protect young women from sexual assault and rape, and it will save lives. Please don't let what happened to my beautiful daughter Hannah happen to another young woman in Virginia. Thank you for your time.
Thank you for your testimony.
Mr. Chairman, members of the committee, good morning. My name
morning.
is John Graham. I'm Hannah Graham's father. I was told I should be brief. I listened carefully to Senator Obenshain, and I cannot add to his description of the merits for the measure. I will not repeat my wife's testimony either, but I would simply say to the members of the committee that I regard this as a use of a robust means of identification. DNA, if you like, is a 21st century fingerprint. It can be used to secure convictions. It can be used to exonerate, but most of all, it is a means of robustly identifying people who were in places, a robust means of identification. What follows from that. I understand there have been some concerns around privacy, and because DNA is such a personal part of a person's very, very being, and just reflects. I reflect that in the years since the DNA testing technology first became known, it is now commercially available. You can send a buccal swab off to organizations such as Ancestry.com and find where you came from. I think the concerns of the privacy of these people who are so far from societal norms that they have been convicted of serious misdemeanors or felony offences is something that I'm far less concerned about than using this technology as a targeted means to provide some additional risk-based oversight, evidence-based oversight to prevent further crimes. I think this is a public safety measure, and I strongly urge members of the committee to support the measure. Thank you.
Thank you for your testimony, Mr. Graham.
Sheriff Chip Hardy in Albemarle, thanks for letting me appear in front of you this morning. Just briefly, we had the first data bank established in 1989 in Virginia, and it languished for about 10 years. It wasn't properly funded. I got behind it in 98 after the little List girls were murdered up in Spotsylvania, and we started lobbying the General Assembly, and in George Allen's outgoing budget, we had bipartisan support, and it was fully funded. Within a matter of 2 to 3 years, we went from having 1 to 2 hits in Virginia to 2 to 3 hits a day in Virginia. It was phenomenal. I was running investigations in the city of Charlottesville, and we led the country for 3.5 years. We had 57 matches in the first 3.5 years. So all that was very exciting. I got just as excited when I saw the data coming out of New York State 4 years ago. They had added all misdemeanor offenses. I brought that forward, and we added a few more. Well, now we've got, the Crime Commission's done a great study, which pretty much mirrors what we're seeing coming out of the state of New York. If you look at it in New York, assault and battery, trespass, and petty larceny are their top 3 that give them hits in their database. That's 3 of our top 4 or 5 in Virginia. So I guess human beings are human beings wherever they live. And it's amazing because in the first 5 years, they've made petty larceny an offense you took the DNA. Just the first 5 years, they matched to 78 homicides, 343 sexual assaults, 235 robberies. So I think it's going to be very exciting. If you all pass this, if one of you go back 2 or 3 years from now and say, show me what that did for us, you're going to be astounded. The last topic I want to speak on was innocence. I'm not just a lock 'em up, throw away the key guy. I work with the Innocence Project. I have helped exonerate folks. I'm working on a Yen Surin case now that many of you all are familiar with. And what we're finding through the Innocence Project alone, 325 people have been exonerated with DNA, 20 who pulled time on death row. 2/3 of those folks are minorities. I think DNA and DNA data banks are the best thing to ever happen to minorities. And I've called for a Justice Commission to look at lessons learned from DNA exonerations to improve the way we do lineups, to force people to videotape interrogations, to look how we use jailhouse informants and so forth. So I just view it as a great move forward for the justice system, and I hope you support this. Thank you.
Senator Saslaw.
Sir, what was the disposition of the trial? He's been tried.
Matthews.
Yen Surin?
Yeah.
Yes, sir. He was.
No.
Matthews.
Talking about Matthews.
Matthews got multiple life sentences. Our Commonwealth attorneys will speak briefly. He handled the homicides in Albemarle County.
Now, I'm curious as to why you didn't get the death penalty.
Oh, I'll let.
Because it was a resolution that, my name is Robert Tracy, Commonwealth's attorney for the County of Albemarle. And thank you, Chairman Openchain. I will give my remarks briefly, and then I'll answer your question if that's okay. First, let me say that it's an opportunity, and I'm grateful to be here to testify in support of this bipartisan recommendation to enhance DNA collection for additional Class 1 misdemeanors. And Chairman Obenchain provided an outstanding summary of how we got here and where we're going. DNA is a proven tool to solve crime and to exonerate the innocent. You've heard civil liberties concerns, but I would challenge anyone here to bring to your attention a proven case of abuse, of unlawful collection or dissemination of DNA since the Virginia Data Bank was established in 1989, we are aware of none. Among the special functions of a prosecutor is to seek reform and improve the administration of justice. This measure does so in a manner that protects civil liberties, preserves our traditions of justice, while making our communities safer and the Commonwealth safer, by sparing future victims of crime and their families unspeakable and preventable tragedy and suffering. So with respect to your question, Senator, the resolution of that case reflected the recommendation of parties and victims to those offenses. Mr. Matthews serving 4 life sentences for the offenses he committed, and he's serving those that penalty right now in that time at Red Onion. There's no possibility of early release or geriatric release according to the terms of that resolution and that plea agreement. I'd be happy to answer any other questions you might have.
Thank you.
Let me make one more point. We hear about bipartisanship. This is a rare opportunity for bipartisanship, and I urge this committee to take bipartisan action to make the Commonwealth safer and better. Thank you.
If I can, just and you may want to hear from opponents.
Senator Obenshain, do you have any other folks that would like to speak as a witness to you, or the others that would like to speak in favor of the measure?
I would just say that if you have further questions, the Crime Commission is here. They did an exhaustive study. Senator Howell and I were there, and Senator Norman at the time that this was adopted. It came out on a unanimous recommendation from the Crime Commission to do this. And Senator Saslaw's question, I mean, this isn't about necessarily about getting convictions. It's about preventing these crimes. And these are 2 murders that could have been prevented.
If there's no one else that'd like to speak in support of this, are those that would like to speak in opposition? Come on up.
Mr. Chairman, members of the committee, first let me say I stand here with some trepidation because I certainly share the concern about the parents and the situation they've gone through and the sadness that we all have about the outrageous crimes that were committed against their daughters. And, but it is important that we make the right decisions for all the right reasons. And several concerns came up for us, which we addressed to the Crime Commission. And so these are not things that the patrons have not heard before. But there is something about the Crime Commission's research that I think it's important to underscore for you all. The criminologist who presented the research was extraordinarily careful over and over again to say that the data they had showed associations, not correlations. And every time somebody tried to go to correlation, which would suggest a strong linkage, she would back up and say, no, it's an association, which means that the data is pretty soft in terms of what it proves. She also said quite specifically that most people who commit misdemeanors do not go on to commit heinous felonies and violent acts. Most people do not do that. So where do we end up? Well, I mean, the hits in the database are down since 2010, 40% down since 2010. The fact is that the larger the database has gotten, the fewer hits we have. And most of them, 2/3 are for minor crimes, not heinous violent offenses. And increasing the size of the database routinely encourages and increases the likelihood of false matches, and then we have to deal with the reality of whose DNA gets in the database. As long as we are disproportionately arresting and prosecuting people of color in this Commonwealth, that means that the database is going to be skewed also racially. And in that circumstance, particularly since we also use our database for familial searches and things that go well beyond the individual, the potential breach of privacy or the intrusion on people's privacy is not insignificant and should be considered. DNA is not like fingerprints. It may be easy to get it from the inside of your cheek, but it is the most private and personal information you have about who you are. And we should not be putting that in a database without a correlation a linkage that is much stronger than an association. And so we would urge you not to go this direction, even though we fully understand the reasons for the advocacy and have great sympathy for the reasons for the advocacy that we go here. And finally, there are a couple of the crimes on the list of the bill as introduced, including obstruction of justice, which are among the most subjective crimes we have in terms of the standards on which we choose to arrest people. So I understand that this is after conviction, but this is a circumstance and situation in which we should be very exacting about these expansions and thoughtful and indeed demand that they be evidence-based by something more than an association. Thank you.
Mr. Chairman, I have a question.
Senator Edwards.
You said DNA is not like fingerprints, but it's pretty darn close, isn't it?
Well, I would argue that a fingerprint is, yes, a physical identifier,
Right.
and you leave them everywhere. But the DNA is the most private and personal information about who you are, where you came from, what diseases you might be subject to. I mean, it's very, very private, and the fact that we can get it easily doesn't mean that it should be something the state takes lightly.
Mr. Chairman, my question is people say DNA's modern fingerprints, and it's pretty darn close, isn't it? But 99 point whatever the percentage is?
Mr. Chairman, I would argue that it is, in terms of identifying people, it is similar to a fingerprint. In terms of what it tells you about the person and their family, it is much different than a fingerprint.
Well, I understand that.
Mr. Chairman, there are people right now purporting to be able to give you a picture of somebody based on running their DNA. Now, I know Black Hispanics and white Hispanics and people of all different colors living in different regions, and yet there are folks in Tidewater right now trying to use software that takes a DNA profile and gives you a picture as if it were accurate in terms of who that person is.
Mr. Chairman, this is not being indiscriminately revealed. It's only people after the conviction and only used for law enforcement purposes. Isn't that right?
Mr. Chairman, I understand that, but I could make the same argument about taking everybody's DNA when they graduate from high school or get a DMV license. It would certainly improve our ability to prosecute people.
Mr. Chairman,
Senator Howe.
I'm wondering if we could hear from the Crime Commission about the issue of correlation and association. She explained it at the time we were discussing this there.
Could we just make a call to see if there's anyone else who would like to speak in opposition? And then we'd love to hear from the Crime Commission. Anyone else who'd like to speak in opposition to this bill? Please come on up.
Good morning, Mr. Chair, members of the committee. My pleasure, and I apologize if my linguistics have taken on a life of their own. Christina Arrington, Crime Commission staff.
Thank you.
You can absolutely use the word correlation. My hesitation with that is that for some folks that implies that there's a statistical correlation. There's also statistical association, so that's why we just changed the word. It was as simple as that. No type of hidden agenda per se. At the end of the day, the data is what it is. In order to carry out a bivariate correlation, the nature of this data did not allow us to meet the assumptions to carry out a statistical bivariate correlation. That does not mean an association or correlation doesn't exist. We just can't apply a statistical number next to each relationship between the misdemeanor conviction and the felony conviction.
Okay. Thank you. Are there any other questions of the witness?
Mr. Chairman.
Senator Pete.
And I don't know if you have this information, but what percentage of the misdemeanors do these crimes cover? How many misdemeanors are committed? And then out of those that are committed, how many of these?
Yes, Mr. Chair, Senator Peake, the list we looked at originally, there was 350 misdemeanor offenses which require fingerprint plus trespassing, and this is a subset of that. So there were only 64 offenses that had a 5% threshold for being related to a subsequent felony conviction. And we looked at those 64, and that's how we narrowed it down to 7 eventually.
Mr. Chairman, how many offenses were committed? Do you have those numbers? Like in a year, how many misdemeanors committed, and of that number, how many are covered by these statutes?
Unfortunately, another limitation of the data, we looked at conviction data only. So if anything, the numbers are understated. There's more that's going on because it doesn't capture the rates of actual offending, arrest, charges.
What, I mean convictions. All right, let me try if I can state
Senator
this.
Peake.
Mr. Chairman, thank you. How many misdemeanors convictions are there in the Commonwealth? And of those convictions of misdemeanors in the Commonwealth, how many of them are covered by these that we're adding? Like, are there 500,000 committed and this covers 400,000, or does this cover 100,000?
Right, we don't have that information readily available, but I can certainly get that information from the Sentencing Commission ASAP.
And Senator Peake, I think the witness said that it was sort of impossible for them to put a number or percentage
And it may
beside this,
be.
but that there was a direct correlation association between
What I would
the
add
offenses
is
committed.
that in 2015, we allocated a specific sum for this DNA testing. And the offenses that are being added under this actually can be tested for that same amount of money. It costs less to do the testing for the offenses added in 2015 than we thought it was going to cost. So this costs no extra money, and it does capture those offenses that have an association or correlation with future violent, felonious behavior.
Senator Obenchain, I think the chairs of finance still would like to have this come to finance, is my understanding.
Mr. Chairman. Mr. Chairman.
Senator McDougal.
While they're up there, when you're saying association and correlation, I heard a 5% number. What association or correlation do each of these have for those of us who are not on the Crime Commission?
Mr. Chair, Senator McDougal, that 5% was just a threshold, not a correlation number. When we had that list of 350, a number of them could just be disposed of readily because there were 0 convictions, or some of those misdemeanor offenses had since been repealed. The 5% just showed the subset of misdemeanors that were convicted of misdemeanor X, and 5% of those went on to commit felony Y over the next 10 years following the misdemeanor conviction. So no correlation, just a threshold.
Mr. Chairman, so each of these are at the 5% level?
Oh, these are much higher.
Okay,
That's
can
how
you
we
tell-
got our initial 64.
Can you tell us where each of these are?
They
is
all
what I'm
fall
asking.
between 18 to 23% of the subset offenders that are convicted of one of the 7 misdemeanor convictions and subsequently convicted of a felony conviction 10 years after that.
Mr. Chairman?
Senator McDougal.
Were you able to ascertain through the data that you had whether when a person was convicted of one of these offenses, if they were also convicted of another offense which we already collect DNA for?
That certainly occurs, and we saw that with the existing 14 misdemeanors, that as a proxy to see how many samples might need to be taken, less than half actually ended up going into the data bank because they were already there. Their samples were already in the database for prior felony convictions.
Mr. Chairman.
Senator McDougal.
So then that makes my next question maybe even more concerning to me. So of this group, that 18 to 23% association, do we know how many of those are also being convicted of some other offense that would have their DNA into the database? And not only convicted, but charged, because certainly if you're charged with a violent felony, then your DNA is going into the data bank, even if you're charged with breaking and entering and you're convicted of trespassing, DNA still went into the database to be tested.
Right, unless if you're convicted for that arrest, it'll stay in, but if not, it's expunged if you don't get convicted.
But we've run it.
Correct. The charges, we don't have any charge data, and the numbers are aggregate in nature. We would have to drill down further, get the individual conviction data to see if there were multiple convictions for each individual offender.
Okay. Senator Sasslaw?
Mr. Chairman, I move that Senate Bill 565 be reported and referred to Finance.
Second.
Motion properly seconded to report the bill and re-refer to Senate Finance. Clerk, please open the roll.
Ayes 13, noes 2.
Mr. Chairman, members of the committee, thank you very much.
Sir.
I've got a.
Mr. Chairman,
Senator McPike.
I believe the previous chairman was also going to have my DNA bill also heard consecutively, a similar subject, Senate Bill 644.
Okay, Senate Bill 644.
This bill is similar, but it provides for the cases upon arrest of indecent exposure or obscene sexual display, two sections of the code. Existing in our code today, existing for burglary, rape, other entering a house, other code provisions require the DNA collection upon arrest. This adds indecent exposure and obscene sexual display. This comes about after discussing from my local Commonwealth Attorney's Office, and actually some of Senator Reeves's former colleagues and detectives on several high-profile cases in Prince William County. One of which was the East Coast rapist, which raped and assaulted 22 women over 15 years. The commonality with those was that, in fact, these and several other individuals in these cases were arrested. In fact, upon his Aaron Thompson's final arrest, his quip to the police was, "What took you so long after 15 years?" That's frustrating to police officers and detectives work on the case when, in fact, they had the gentleman arrested for indecent exposure. And in talking with, Prince William County police detectives who worked that case were extremely frustrated. In fact, just a mile from my house, 3 girls were taken by gunpoint by this individual on a Halloween night. 2 of them raped. This individual raped and or assaulted 22 people, ranging from 11 years old to 47 years old during his tenure being out. And the fact is, we had opportunities, he had interactions. We have several other cases. I've Googled most of your areas as well and have similar cases of people with indecent exposure that go on to have serious repetitive issues over time. This is similar, but it is, I think, an important sort of marker in these type of cases, and which is why I presented the bill and appreciate the committee's consideration of this.
Any questions of Patron?
Yes, Mr. Chairman.
Pete.
And Senator McPike, it seems to me the 2 offenses you have would be the ones most indicative, and why would they not have been included in the ones that Mr. Obachane? Do you have any information from the Crime Commission?
It may be the Crime Commission. Maybe Dr. Arrington could drop a lifeline to Senator McPike.
Mr. Chairman, Colin Draper, staff attorney with the Crime Commission. Senator Pete, to your question, the reason they weren't included is because those 2 crimes are already included as misdemeanors where a DNA sample is required upon conviction. This proposed legislation actually moves the collection at the time of arrest.
All right.
Thank you.
All right. Anybody wish to speak in favor of this bill? How about opposed?
Move to report.
Mr. Chairman,
Senator McDougal.
before we get there, I think we heard earlier that about the creation of the DNA databases, and originally they were for conviction. 2002, when I was in the House, I carried the bill that allowed us to have DNA testing at the time of arrest. And at that time, it was violent felonies. We fought very hard to include breaking and entering because of the direct correlation. And we also fought very hard to have somebody who was not convicted to have their sample removed. Through that conversation, when we went to breaking and entering, there was a lot of concern back in 2002, so was that 17 years ago almost now, that we would include misdemeanors at the time of arrest. I think we see today that we're adding things, but this is a threshold jump if you add misdemeanors at the time of arrest, not beyond reasonable doubt, not guilty, but at the time of arrest. So as the committee's having the conversation, I think it's different than the conversation we just had on the previous offense, at least in that one, you had to be convicted. This is somebody goes to the magistrate, takes out a summons against you, now you have to give your DNA. So I just want to bring that to the committee's attention.
And question, and I don't know whether you've got the data readily available, but you gave the statistics for the correlation for the other offenses. What is the correlation significantly higher for these two offenses?
Equal or greater. I can look for these two crimes specific, but the existing 14 are equal or greater than, or equal or less than the 7 being proposed.
Can you come up? I'm sorry.
Mr. Chair, Christina
So-
Arrington, Crime Commission staff. Give me 1 minute to pull up the existing 14. Information.
Right, but I want to. Interesting.
Earlier, I'd mentioned it was 18 to 23%,
Right.
and that's a similar percentage that we see for the two offenses being proposed in this particular bill.
That's for
For
convictions.
convictions, correct.
Mr. Chairman,
McDougal.
do you have any data on the individuals who are charged but not convicted of these offenses?
We do not have that information readily available, but we can obtain that.
Okay. You say you can obtain it. I mean, you can obtain it within days?
I would have to defer to the Criminal Sentencing Commission,
Okay.
but we can get an answer from them
Well,
to see if that's feasible.
And I ask that because if this reports out of here, it does have one more stop to go before it hits the floor. So it would go to the Finance Committee, and aspirationally, maybe you can work on trying to get those figures before, depending on the
And
outcome
this is
here.
upon arrest as well. We might be able to consult with the Virginia State Police as well to get the number
Okay.
of arrests.
All right. Well, the bill's before us. And re-refer to Finance. It's been moved and seconded to report and re-refer this bill to the Committee on Finance. Clerk will open the roll. All right.
Thank you, Mr. Chairman.
Yes, sir. You may want to coordinate with Crime Commission, see what you can get. All right. Scott, I'm sorry.
Right, so my last bill was Senate Bill 938.
Is this your last bill?
Today.
You should be so lucky. We need a special session just for his bill.
61. 61.
Did you have a case? All right, let's go.
Mr. Chairman, maybe we should have a rule that if you have more than 25, the rest are PBI'd, just in principle.
Be nice.
All right.
Mr. Chairman, now I know why the House adopted a rule about bills.
Senator Servell, my understanding is you want to make people who hire an independent contractor register that independent contractor in whatever the employer database.
Right.
Is that right?
Yes, and there's a substitute, the strike two code sections, which you all have already voted to repeal, and another one.
Do we have that substitute?
Mr. Chairman, I would prefer to read the amendment.
Okay.
On page 5, strike lines 246 through 262, taking out the code section that the Senate had voted to repeal in Senate Bill 51, which was Senator Edwards' bill. And on page 10, strike lines 406 through 432, which deals with healthcare coverage provided by employers, and that section should not apply to people who employ independent contractors.
On page 10,
On page 7, lines 406 through 432.
I'm sorry, can you tell me that one more time?
Page 7.
406 through 432.
Yes, sir.
Okay. All right. Senator Stewart moves, Senator McDougal seconds the adoption of those amendments. All in favor signify by saying aye. Aye. All opposed? amendments are adopted. Go ahead. Tell us what your bill does.
Thank you, Mr. Chairman. So this is a bill that arose out of some conversations I had with the Department of Child Support Enforcement about child support collections and independent contractors in terms of their difficulties collecting child support. So the committee has some background. Basically, all this does is it applies the same requirements for W-2s for people that are independent contractors engaged in a trade or business. Not all independent contractors, only independent contractors get engaged in a trade or business. So in 2001, Jay Lark did a...
So if I've got a brick mason who comes out to repair something, I mean, that's a trade or business, right?
It is, but you typically wouldn't write a 1099, issue a 1099 for that kind of person.
Why not?
If you're an individual...
I might not, but shouldn't I?
If you're an individual person and not a business?
Right.
I don't think individuals have an obligation to do 1099s, only businesses do, I think.
Okay.
And
Mr. Chairman?
Mr. Bersham at the DCSC can probably answer more specifically, but.
And I'll tell you, just as a small business person, it is a pain doing this to begin with. And I just worry about adding new burdens on small businesses. And I'm a lawyer. I know what an independent contractor is. I'm not sure that everybody does, and requiring them to, and we're defining it here as well, which troubles me, concerns me as well, adopting a definition that I think common law has fleshed out pretty thoroughly, but imposing that obligation on businesses to do that is, that's concerning.
Mr. Chairman?
Senator McDougall.
You took some of the words out of my mouth. If we're changing the definition of independent contractor and thus changing decades, if not longer, of case law, because we're putting in a definition that does not exist, I have a real problem with that. If you were saying that TNCs or entities that we would traditionally call Airbnbs would have to comply with this, you could probably get me, but the current version is, I think, much more sweeping than what Senator Serval is articulating.
This bill doesn't change the definition of independent contractor for everything in the world. It changes it for purposes only of payroll withholding orders and also only for purposes of the new hire database.
So we've got two definitions of independent contractor, one this statutory definition and one, I mean, do you not believe that courts are going to look at that and say General Assembly has indicated its intent to change the definition of independent contractor?
No, because it's only changing it for purposes of an independent contractor for purposes of the new hire reporting, which is mainly for DCSC, and only for purposes of a wage withholding order. But there's other places in the code where an independent contractor is dealt with.
Mr. Chairman?
Senator McDougall.
Couldn't you accomplish the same thing by not changing the definition, but saying that if you're TNC, you're required to provide this information, or if you're operate a platform that facilitates the rental property, you're required to submit to it? I mean, couldn't we get it a different way than, because I mean, I agree with Senator Obenshain. I don't think that's what you articulated you're trying to do is not change decades of independent contractor litigation that's resulted in a lot of established case law. But I think that unwittingly you could do that by changing those definitions. If you said these entities that run these platforms are required to comply with this particular section, I think you might have some of us, but when you start touching that definition, it gets extremely concerning.
No, I mean, I appreciate that, and that is definitely an alternate approach that could be done to capture a portion of these entities, and probably a good bit of them. I haven't talked with DCSC about exactly how they would view that, or I don't know, maybe Craig can talk to you about what their experience has been.
This isn't an agency bill, is it?
It is not, but
It's
the
not.
administration does support the bill.
Okay. All right.
let him talk about it.
All right, be more than happy to hear from folks who wish to speak in favor of it. Yes, sir.
Chairman, members of the committee, Craig Bersham, Deputy Commissioner for the Division of Child Support Enforcement. Currently, the division has no way to know if somebody is working in the gig or the sharing economy. There's no notices given to us. The only way we would find that out is if a parent calls us and says the non-custodial parent is working in that economy. This bill, what it does is would require any association or business to report, just like it would to the IRS for the 1099, to our new hire reporting. So the same way it reports employees, it would report these independent contractors to the new hire. This would allow us then to issue a wage withholding on this income. I think to the point of the definition, we do define this in the new hire statute, and it's defined as not an employee for purposes of Federal Insurance Contribution Act and the Federal Unemployment Tax Act, and it looks at the 20 factors by the IRS. That's commonly what a business would have to do to determine whether or not they're issuing a 1099. And in fact, it says in this statute, in this amendment or the bill, that they can comply by merely sending a copy of the 1099 or sending the data elements, the name, the address, and when the service was done, when the agreement was done. So it's a very simple process. It's a process that businesses are very used to doing for employees. Almost every platform. The problem, I think, Senator McDougall, is there are so many platforms in the gig economy now, and there's so many different. You have transportation network companies. You have masseuse coming out to your house under Zeal. You have Airbnb. I'm not sure you could quantify every platform that's out there, and they've expanded just exponentially, and we don't have any way right now to currently get at that money.
Senator Stewart.
What's the penalty if you don't comply with this?
I believe the penalty was $1,000.
Where's that found? Because
Let me, hold on.
not sure I could find it in here.
Mr.
I
Chairman.
think it's in the 20.
After that.
Mark.
I think it's on line 395, maybe?
All right. Is that it?
It's the only question I had.
Senator Peterson and Senator.
Yeah, I had a question, and I'm less familiar with Uber and Lyft. I'm very familiar with how taxi cab companies operate, and there's been a big dispute as to whether or not they have to pay workman's comp for their drivers, who have always been considered as independent contractors. Is this bill, is this going to kind of move the needle towards requiring workers' comp to be paid for drivers and other sort of benefits that would?
No, Senator, it's only addressing child support and requiring a wage withholding order.
Okay, further question.
Sir
You
Peterson.
mentioned the 20 factors test, which is an IRS test, correct? And I guess my question is, if we sort of make these drivers as quasi-employees, at least for purposes of this statute, is that going to start fulfilling one of the 20 factors tests such that they're going to become employees?
Chairman, and I don't believe so, because it's really not making them employees. They're clearly independent contractors. All it's doing is requiring you to report the independent contractor to the new hire, just like you would an employee, and allowing the division to attach that money to pay their child support.
Yeah, the 20-factor test doesn't have anything to do with that. I just pulled it up, and I can show it to you here on my computer if you want to see it.
Okay. All right, Senator Peak. I'm sorry, you finished, Senator Peterson?
Yes. Mr. Chairman, then, this goes back to a point that Mr. Chairman made. Who is required to submit 1099s and when? And where's the 1099 law?
It's
That's the IRS.
Yeah.
It's really complicated.
Very complicated. Yes.
All right, other questions? All right, anybody else wish to speak in favor of this bill? Anybody want to speak in opposition to the bill? Bill's before us.
Just say a couple of things.
Real quick.
Really quick. Right now, the state is owed about $2.4 billion in delinquent child support. There's 300,000.
State is owed or?
Children are owed.
Well, children are owed, but also as to the point of the bill that's on the floor today by Senator Peake, I mean, if child support's not being paid and TANF gets paid to supplement that, part of the way we recover our TANF costs is by recovering child support from people. And so some of this money is actually owed to the Commonwealth and reduces our TANF obligations every year. So that's just one thing I want to point out, which I think it's important. But the out of those 300,000 active cases, I think 176,000 of them currently have arrears on them. And if we're going to efficiently collect, like 15% of workers today are operating in this gig economy, and is growing like crazy right now. We need to do something to fix it. And I thought this was a reasonably tailored approach to fix it. I don't think it affects the underlying common law of independent contractors at all.
Mr. Chairman?
Senator McDougal.
Of the 61 bills that Senator Serval has, I think conceptually this is not bad in concept of trying to get the support for the children.
Something to do with faint praise.
But I think it really opens up a potential can of worms as we're dealing with independent contractors. So I'm going to move that we carry it over for the year and let him see if he can work on a definition of some of those TNCs and other platforms, because me personally, I would be comfortable if we moved in a direction to try to get that particular revenue back for those kids because they deserve it, but without upsetting the entire case law of independent contractors. So my motion is that it be carried over for the year.
It's been moved and seconded. The bill be carried over for the year. Clerk will open the roll. All right.
Ayes 11, noes 4.
All right. Senator Eben.
Thank you.
Thank you, Mr. Chairman. This is SB 579. This deals with a topic, similar topic, or really the same topic and a similar approach, but a bit different than Senator Stanley's SB 181 that you sent to Finance. But I did want to point out the distinction. We know that as of now, there's 647,000 people whose licenses in Virginia have been suspended only for non-payment of court fines and costs. So what this bill would do is provide those individuals 90 days to pay the amount owed, and the court could take initiative to have them, require them to tell the court why they can't pay it immediately and ask for an extension beyond 90 days, that sort of thing. So Senator Stanley's bill, my understanding, was wider in that it gets rid of those fines and fees, but there's someone here from Department of from Secretary Moran's office who could speak further to the difference.
Mr. Chair, members of the committee, my name is J.K. Davenport, Deputy Secretary of Public Safety and Homeland Security. The difference is that it gets this doesn't just automatically suspend the license. It also changes from 30 days to 60 days to pay off the fine. However, instead of just getting rid of the provision to suspend the license for failing to pay fines and costs, it allows the court to question the defendant as to why the fines and costs could not be paid. It's a narrower approach than what Senator Stanley's bill is.
I mean, isn't that what the Supreme Court just adopted new rule to deal with, to give it that discretion?
But that was just a payment plan. That was just a payment plan. It continues it on and on and on. If the person is not able to pay, then their license is not suspended.
That's a payment plan. This is whether it's waived altogether.
Yeah, under this bill, they would not be suspended. But this is another vehicle on a similar concept. So what I was going to ask is Senator Stanley's bill is in Finance, that you might send it to Finance and see which is their preference, because there is a fiscal impact on his. This one says no statement needed. I want something that'll pass the other body, but it's up to the committee how you want to handle that.
Mr. Chair.
Senator Peterson.
Okay, so just so I understand this, if you don't pay the fines within 90 days, you're then brought before the court on what we call a show cause hearing.
No, the court at its own, the court would bring you before it. You would not be required, would they be required to have a hearing according to this?
Okay,
The
court
court
may.
may issue a show cause to bring forth the defendant to
All
come
right,
and.
so yeah,
Yes.
but my question is, further question, Mr. Chair.
Senator Peterson.
How's the court, first of all, is this a circuit court?
This could be in circuit court or general district court.
Okay, who's gonna bring this to the judge's attention? What discretion are they gonna have? I mean, our circuit court judges are pretty busy. I mean, they don't typically follow this stuff in their spare time. Who's gonna sort of, I'm sorry, I'm looking at her because I think, who do you envision would actually sort of take the initiative here?
The court.
Okay, but who at the court? They're not looking over default notices.
No, but the clerks do keep track of whether court costs and fines are paid.
Mr. Chairman. Mr.
Senator
Chairman,
Edwards.
The reality is, they don't. The court's not gonna do it, the clerk's not gonna do it, the prosecutor's not gonna do it, so who's gonna do it? That's the problem. That's the problem with this approach. Stanley's approach is a better one.
Yeah.
I mean, I do this occasionally. And I
Oh,
can-
if his bill comes to the floor, I want to vote for it. I like his
Yeah.
bill a lot, even more.
But
than
I would
my
like
own.
to know-
I just want one of them to pass.
Practically speaking, and there's several of us know how the system works, the clerks are busy, and they're not gonna go through it and say, okay, it's now time to do a show cause order, Judge. And the judges will sign whatever you give them, but they're not gonna go through their docket and say, I'd like to do more work this afternoon.
Senator McDougal.
Mr. Chairman, I must be getting soft in my older age as we go through this, based on the two motions, one I just made, one I'm getting ready to make. But I think with what Senator Eben is talking about, he wants a vehicle to go through. Senator Stanley's is on the faster track to move through that. So I would move that we carry Senate Bill 578 over for the year, so that if there's a problem with that track, there's still a mechanism for this one to be alive.
I would suggest maybe that Senator Eben get together with Senator Stanley so that Senator Stanley has a substitute available in the event that it is not smiled upon, so that might be considered as an alternative. So friendly suggestion.
I think that would be fine. Thank you.
Okay. All right, all in favor of, clerk will open the roll on the motion to carry it over.
Thank you, Mr. Chairman.
Thank you. All right, next, I think we've got members of the committee.
Mr.
Senator
Chair.
Chafin, 422.
Mr. Chair.
I'm sorry, Senator Peterson first, I'm sorry.
Yeah, this is, and I'll maybe just do it from here.
278.
This was Senate Bill 278. This was the prompt settlements for eminent domain. And I've talked with the rep from VML and also Fairfax County, and I think I have some agreed language for to be drawn to the substitute. Mr. Chair, if I can report it.
Yep.
This would be following the language on lines 19, 51, and 56. Insert the sentence, "The attorney or landowner receiving such funds shall be responsible for paying all outstanding liens on the property." And I'd
All
make
right.
that motion.
Any concerns about that? It's been moved and seconded to adopt those line amendments. All in favor signify by saying aye. Aye. All opposed. And with that, is there peace and agreement on the language of the bill?
I think so.
Okay with it?
Make the motion to report.
Hang on, I'm sorry. One more time, chap.
Oh,
Your
the
amendment.
the attorney or landowner receiving such funds shall be responsible for paying all outstanding liens on the property, period.
All right, the bill is before us as amended. You want to make a motion? All right, it's been moved and seconded that the bill is amended be reported. All in clerk will open the roll. All right, bills reported. Senator Chafin, Senate Bill 422.
Thank you, Mr. Chairman. This is a bill that we brought back for reconsideration. The original bill, deals with the duty of the
Senator Chafin moves, Senator Stewart seconds the adoption of a substitute.
do.
All in favor signify by saying aye. All
Aye.
opposed? All right, substitute's before us.
So what the substitute does, in addition to the original bill, it provides for a notice to be given to junior lien holders, after which, in the order of their priority, subsequent debts and obligations of the deed and inferior liens that are out there, along with interest, can
Ben?
be paid by the trustee.
Is everybody comfortable with this? Any opposition that you're aware
I'm
of?
not aware of any opposition.
Any member?
This came to me from a commissioner account from Jack Rust as an idea that, people are holding these monies, and it just seems logical to go on and get the business taken care of when you're doing the foreclosure.
And banks are okay with it?
Banks are okay
I
with
assume
it.
by
Yes.
virtue of your standing there?
Yes.
And any member of the committee have any questions or concerns? Anybody in the audience wish to speak to the bill? The bill's before us. It's been moved and seconded that the substitute be reported. Clerk will open the roll. All right. Senator Deeds, 685, gone. Senator Howell, 135. Oh, boy. Senator Howell, I don't see Mr. Benjamin, so we may want to go to 457 first.
Good. Both of these bills are Crime Commission bills. This one dealing with restitution was a unanimous Crime Commission recommendation. It actually, the big word restitution, this is actually a very small piece dealing with crime victims and allowing them to request that their personal information be kept confidential.
And
the
Senator
two
Howell, I think it
parts-
just extends the confidentiality to email addresses and cell phone numbers,
it.
essentially. Recommendation also from the Executive Secretary's restitution work group, I'm led to
As I remember.
understand. Anybody, you aware of any opposition to this bill?
No.
Anybody in the audience wish to speak in favor of or in opposition to the bill? You like this? All right, you like it? It's been moved that this bill be reported. Clerk will open the roll. All right. All right, Senator Howell, now we'll do 135.
Thank you. 135 deals with the admissibility of prior inconsistent statements. It also is a Crime Commission bill. It passed not unanimously, but 10-2. Currently, we can only use prior inconsistent statements to impeach the credibility of the testifying witness in a criminal case. 47 other states have a different approach, and this would create a new section of the code which would allow the court or jury hearing the criminal case to consider the prior inconsistent statements of a witness as substantive evidence against the defendant. The court or jury will be permitted to consider the prior statements in determining whether a defendant is guilty of the charged offense. And this approach allows the court or jury to consider all relevant evidence, to observe the demeanor of the witness, and to hear an explanation for any discrepancies between the testimony and the prior inconsistent statements.
Mr. Chairman.
I have a number of lifelines, human lifelines, from the Crime Commission.
Well, yeah, and
who can help
let's,
with this.
and
I believe Mr. Doucette is also here.
we heard we heard this bill last year and heard a lot of discussion about it. It wound up going back to the Crime Commission for an additional look. Let's hear from those who would wish to speak in favor of the bill. I don't know whether the Crime Commission has anything that Colin, you'd like to say. I know that that Mr. Doucette has some well-formed thoughts about this.
Thank you, Mr. Chairman. Colin Drabert, Staff Attorney with the Crime Commission. Madam Senator. The Crime Commission did examine this issue, conducted a review of the evidentiary rules of the 50 or 49 other states, federal government, and DC in regard to this issue, so we're happy to answer any questions. This was endorsed by the Crime Commission, but in terms of the ultimate issue would be a policy issue for the consideration by this body. So if there are any specific questions, I'll be happy to address.
Mr. Chairman? Mr. Chairman?
Senator Edwards.
We now have federal, state, Virginia rules of evidence, and the Supreme Court can come down with proposals too. Has the Supreme Court weighed in on this at all?
To my knowledge, the court has not taken an opinion on
Okay,
it.
Mr. Chairman, wouldn't this be a radical change in the law of Virginia?
This would be a significant departure from current evidentiary practice.
Mr. Chairman, now, the federal system has something kind of like this. I forget exactly how it says, but it's much more restrained, correct?
That's correct, Senator. Senator,
Good.
there are two parts of this bill. There's the initial part, which deals with prior statements under oath. That is consistent with the federal rule. There's a more expansive statements underneath that, such as prior statements in writing, recorded statements. That this particular statute is modeled after the statute used in Illinois. That is more expansive.
Mr. Chairman, well, that would be clear hearsay, which is not admissible in court ordinarily because it's not reliable, correct?
Correct.
Okay.
All right.
This is a terrible bill, Mr. Chairman.
Well, let's give Mr. Doucette a chance to speak to it. And I think that people on this committee are pretty darn familiar with this.
Mr. Chairman, Mike Doucette, Executive Director of the Virginia Association of Commonwealth Attorneys, and this bill is, as pointed out, is designed for those cases where there is a commonly significant recantation, where the victim accurately reports the abuse initially, but then recants falsely in cases specifically like domestic violence, sexual violence, those sort of cases. And I use domestic violence as an example, but I realize that this bill is not limited to domestic violence.
Mike, let me give you an example. And I spoke with counsel about this example yesterday, but okay, you've got a domestic violence situation in which there are physical manifestations of the violence. The girlfriend or wife gives a detailed statement accusing the domestic partner of the abuse, and then before trial, at trial, recants, says, I don't remember, or it didn't happen that way. That's what you're trying to get at.
Or it's yes, sir. And
so the prosecutor then impeaches her with that prior inconsistent statement, and you have other physical evidence and the observations and testimony of the officers who arrived there, and there were only two people there. So that statement comes in as an inconsistent statement, right?
It comes in as an inconsistent statement only to impeach.
But not, right. Have you ever seen a jury who's been able to split that hair?
It doesn't get to the jury, Mr. Chair, because
But
many
if there's
times
corroborating evidence.
Corroborated, there may be corroboration that an assault occurred, but who was the criminal agent? Oftentimes, because it's only one, the two people are there, one's the defendant, one's the victim is the person who can identify the criminal agent as to who, but this corroboration as to the injury. But I can't tell you the number of times that staircases and doorknobs are accused of assault. Because when they come into court, the victim comes into court, she fell down the stairs, she fell into a doorknob. And it's the issue of criminal agency.
Officers are good, and they're getting better at making the necessary observations to deal with these sorts of deficiencies. And so they'll testify to abrasions on the defendant's fist, for example, or their excited manner, or the mannerisms that they subjectively observe. That I recognize, Mr. Chairman, that there are problems and deficiencies in cases, but there are an equal number, actually a greater number of problems with false accusations that would then become substantive evidence if a witness recanted at trial.
Mr. Chairman, if I may address the council's comments, absolutely. But the burden of proof remains the same. The burden of proof remains that we have to prove our case beyond a reasonable doubt. The defendant is cloaked in a presumption of innocence. And this gets us to the trier of fact. This gets us by a motion to strike and lets the trier of fact look at these particular cases. It's been brought out, the fact that the first part of this models after the federal rule of evidence. The second part, it goes a little bit more. There are 23 states who have followed the federal rules of evidence. There are 22 other states who have gone broader in the same direction as this particular bill. Armageddon has not happened. We are one of 3 states where this is not the law.
Okay, thank you.
Mr. Chairman, Eldon James on behalf of the Virginia Victims Assistance Network, and I think you were reading my testimony. I will defer to the example you gave, because it's almost word for what message we wanted to deliver, Mr. Chairman.
All right, thank you very much. Yes, sir.
Mr. Chairman, committee members, Jonathan Iglesias with the Virginia Sexual and Domestic Violence Action Alliance. We support this bill. We think this brings us further into alignment with 47 other states who already have this this measure, and we believe that inconsistent prior statements are part of kind of the trauma response that survivors often exhibit, and this allows prosecutors to bring that into the courtroom.
Thank you.
Good morning, Mr. Chair. Sushila Varkey from Virginia Poverty Law Center, and we support this bill.
All right, thank you. All right.
Are you waiting for a motion?
Ready for opposition, Mr. Chair.
Anybody wish to speak in opposition? Thank you.
Thank you, Mr. Chair. Maria Jankowski, the Virginia Indigent Defense Commission. I urge you not to support this bill. This is a sweeping and huge change in the rules of evidence in Virginia. I would note that the victims' statements are, I don't want to beat a dead horse, but they can just as easily be used by the defense attorney. If in many of these instances, the first call may be to the police. The second call is to the defense attorney wondering why we can't get the boyfriend out of jail. Am I going to now advise all criminal defense attorneys to record all of those statements? The problem with this bill is it's not just domestic violence cases. I would note that the sheriff of Albemarle, Sheriff Hardy, when he was here earlier, speaking about his engagement on innocence cases, pointed out jailhouse informants. This would be applicable to jailhouse informants. It would be applicable to any witness who testified. And those informants, those witnesses, are the ones that are most likely to want to provide bad information. There's been a bill, Rule 35 bill, I think it's Senator Stanley's bill, that allows for cooperating witnesses to get consideration off their sentences if they cooperate. This would apply to all of them. And coupling these two things, the federal rules of evidence, the overly broad multi-jurisdictional grand jury that we have, the cooperation, we have the federal system without any discovery. The federal system at least has jinx. I think Senator Howe said all relevant evidence would then come in. This isn't all relevant evidence. This is just the evidence that the Commonwealth chooses to memorialize. The Commonwealth could interview 5 witnesses, and the 3 who give them what they want to hear, they write those down. The 2 that don't, those don't get memorialized. Yes, sir?
Thank you. All right, the bill is before us.
Mr. Chair.
You have a motion, Senator Peterson?
I do.
All right.
I don't do criminal practice, but I definitely do trial practice. And the rules of evidence are set by the Virginia Supreme Court, and there's a reason for that. Theoretically, they are a nonpartisan body, and the only thing driving what they do is reliability of evidence. And I greatly appreciate having this discussion. It's an important discussion. But when you start allowing in narratives that you have no counsel present, it's completely arbitrary as to what gets recorded or doesn't get reported, which the previous witness spoke to. And you don't have the same indicia of reliability that you would have when you have people that swear an oath and then testify in court. I mean, it just becomes a free-for-all at that point. So, again, I don't always agree with the Supreme Court. Oftentimes I do not, but I think they are a fairly impartial arbiter of this section of the law. So,
and you've never brought a bill to change a ruling to the Supreme Court?
Not an evidentiary, not on rules of evidence.
All right, so your motion is?
PBI.
All right. The motion has been made to pass the bill.
Substitute motion that it be reported.
All right. All right, substitute motions before us to report the bill. Clerk will open the roll.
Ayes 5, noes 10.
All right.
Oh, wrong. Did everybody roll? We strike the roll. Yeah, strike them.
I'm sorry?
I thought it was PBI.
No, it's.
All right, motion, you want to make a motion to reconsider,
Yeah, motion reconsider vote, yeah.
because it's been reported. All right, is there a motion to reconsider the vote by which the bill
So moved, so moved.
failed to report? All right, it's been moved and seconded. All in favor signify by saying aye. Aye. All opposed. All right, the motion is to report the bill. Open the roll.
Ayes 4, noes 11.
All right.
Thank
Bill
you.
fails to report. Primary motion is to pass the bill by indefinitely. Can you reverse it, Hobie, or you want to open the roll? Let's open the roll. Easier for the clerk.
PBI, yes, yes.
All right. Yeah, Senator Howell, okay.
Ayes
All
11,
right.
noes 4.
All right, bills passed by indefinitely. Next, we've got Senator Lucas, Senate Bill 987. Yeah.
Thank you, Mr. Chairman. Mr. Chairman, members of the committee, Senate Bill 987 is born out of the violence we saw in Charlottesville over the summer and the threat posed there by the trained and organized militias that came from all over the Commonwealth and the country. On the streets of one of Virginia's cities, we saw organized, trained extremists armed with powerful weapons marching through our streets. The message was unmistakably, and the results was the death of 3 Virginians. Interviews with the leaders of these groups revealed that they were operating as unregulated, uncontrolled, unaccountable, self-appointed so-called security forces. Their appearances and the power of their weapons greatly increased the likelihood of greater violence and confusion and even large-scale confrontation with legitimate law enforcement authorities. We have to make it absolutely clear that these organized, trained, unlawful militias cannot operate within the Commonwealth, and part of that means giving our law enforcement community the tools they need to identify and preempt acts of violence and threat. Current law only prohibits teaching and training with 1 or more persons to demonstrate how to use, apply, or make firearms, explosives, or incendiary devices, or a technique capable of causing injury or death if the purpose is to use these skills in furtherance of civil disorder. Senate Bill 987 enhances the current prohibited paramilitary activity statute by providing that a person is guilty of unlawful paramilitary activity if they assemble with another person or persons with the intent of intimidating one person or a group of people by drilling, parading, or marching with any firearms, explosives, or incendiary devices. This bill will help prevent further violence like what we saw in Charlottesville, in addition to sending a message to any group that elects to assemble in order to intimidate others.
Senator, I think that we all agree with many of your sentiments and motivations. I do, and I hope the ACLU is here, but I do wonder about the constitutionality of this and whether this implicates the right to free assembly. And Claire, around?
Intent to intimidate. Who wrote this?
Yes, Mr. Chairman.
Does the ACLU have any concerns about the implications of this on any component of the Bill of Rights?
Mr. Chairman, obviously, the Bill of Rights and the First Amendment guarantee the right to assemble peaceably. And I think there are some pretty serious enforcement issues around proving this intent. We have not taken a position on this bill. We have stated that we can't support other legislation that's been introduced. I think it's important for the committee to be aware that every single Virginian between the ages of 18 and 55 is by statute a member of the unregulated militia of Virginia. And that is by, in the code, and can be called up by the governor at any time. So I think, there are a number of issues that deserve some consideration
Mr. Chairman.
and discussion in this
Senator
committee.
McDougal.
Claire, I'd ask this of you instead of Senator Lucas, just because of your legal background. This says assemblies of one or more person with the intent of intimidating, drill, parade, or march. Would that not include the National Guard that's called up to keep the peace, or anybody at our military bases, of which we have a number in my district and around the Commonwealth? Because it doesn't say that the person has to be in close proximity at all. So doesn't that, it hits a lot more than the situation that's articulated, does it not?
Mr. Chairman, Senator McDougal, I think that you've illustrated that there are some vagueness issues with this, and it's unclear exactly who it applies to or how it would be enforced.
Well, I appreciate your stepping up. Steve, you have any thoughts about the constitutionality?
I can't say that it's unconstitutional on its face. It may be unconstitutional as applied. It is almost identical to our current statute that criminalizes burning a cross with the intent of intimidating any person or group.
Is what?
Mr. Chairman.
Senator McDougal.
Steve, if the example of all of our military bases or the National Guard, if they are organized and displaying any sort of force to keep the peace, could they not be in violation of the statute? Because certainly their intent is to intimidate. Certainly the military is trying to intimidate some of our.
Mr. Chairman, I don't think so. I think that when they act in that fashion, they're acting to enforce the law, to preserve the peace. I don't think anybody would say that they were acting with an intent to intimidate.
Mr. Chairman.
Senator McDougal.
So you're telling me our military is not trying to intimidate our enemies not to attack us?
Well, Mr. Chairman, that's not a legal question that I can answer.
Okay.
Mr. Chairman. Mr. Chairman.
Senator Peake.
And I think this is to Mr. Benjamin. Isn't that cross-burning statute currently in front of the Supreme Court?
It's the new
No, this is-
statute that is before the Supreme Court.
No, it was before the Supreme Court, and it was unconstitutional because it contained a presumption of an intent to intimidate. That was unconstitutional. This is the current constitutional version.
Mr. Chairman, I have a proposed amendment that would say on line 23, assembles with one or more person with the malicious intent to and does intimidate.
Got that?
And then it goes on to say any person or group by drilling, et cetera, with explosives or incendiary devices, et cetera.
Got all that, Kristen?
Yes, Mr. Chairman.
Is there a second to that motion?
Second.
Really? You like that amendment?
I like that amendment.
Okay. You want to read it?
Mr. Chairman, so on lines 23, it would read, assembles with one or more persons with the malicious intent of intimidating and does intimidate, and then any person or group of.
So that might not get to Antifa and the groups in Charlottesville if they just engage in combat and are not intimidated. Is that right? Steve?
That's right.
Okay. All right, the amendment's before us. All in favor signify by saying aye.
Aye.
All opposed? No. Well, let's open the roll on the amendment. Senator Lucas, you want to cast your vote on the amendment?
I thought I just
Sorry,
did.
There you go.
Oh, I pushed it, it just didn't register.
Ayes 7, noes 8.
All right, the amendment fails. Bill's before us. Anybody wish to speak in favor of this bill? Step right up.
Thank you.
Good morning, Victoria Pearson, Deputy Attorney General, Criminal Justice and Public Safety. Happy to speak on behalf of this particular bill, which we all know addresses some of the big concerns that came out of the Charlottesville incident. This language would be added into the already prohibition in the state code that pertains to paramilitary activity. As was stated by Senator Lucas, it already prohibits the teaching as well as demonstrations of paramilitary activity, training and practicing, instruction with firearms. So this is not creating a new group of individuals that would be banned or a new group of people who could not do things. This just adds to it the conduct of intimidating individuals through marching and drilling while doing so with a firearm. As you may or may not be aware, there was a group of about 32 individuals carrying large rifles dressed in a confusing manner that looked like our Virginia Guard, which were not there for purposes of maintaining the peace. They were not there for purposes of enforcing the laws of the land. They were there for a separate purpose that was their own pecuniary purpose, which was very different and distinct, but could confuse other individuals, which is part of why this particular statute already exists. So this is a language to try to give law enforcement an additional tool to address paramilitary behavior and to reach some of the things that we found very disconcerting about August 12th.
Is this an Attorney General's bill? I thought that you all had a broader bill, maybe through Delegate Price.
We look forward to bringing that bill forward, yes, sir.
All right, is that it pending in the Senate or?
That's House bill.
Okay,
We hope it'll be pending.
okay. All right, thank you very much. Appreciate it.
Mr. Chairman, I just have a question, and I don't want to beat a dead
Senator
horse. As a cadet, I used to drill on our drill team with rifles and bayonets, and it was our intent to beat the other teams, to intimidate them and the whole bit, because we'd like to win the competition. Wouldn't this bill at this point make it illegal for drill teams with military precision weapons and all that stuff to do that? I mean, this would catch them up.
Mr. Chairman, Senator Reeves, returning to Senator McDougal's point, I think that the amendment then would be to say maliciously assembles and so on. That would call out those who are lawfully acting in the capacity that you describe. Just add the word maliciously in front of assemble.
How do you prove a malicious, what is a malicious assembly? What about, well,
bear in mind, Mr. Chairman, that
isn't it in the eye of the beholder? And isn't that what we're trying to, I mean, you know, look, I mean, we certainly want to protect people against malicious behavior, but we also have constitutional protections for unpopular behavior. And it doesn't mean that we agree with it, that we think it's not despicable, but it's a tough line to
Mr. Chairman, you're absolutely correct, but the distinction is that speech with the intent to intimidate is not protected by the First Amendment, and we criminalize conduct and speech throughout the code if it's done with the intent to intimidate.
Mr. Chairman,
right.
Mr. Chairman, further I'd point out, you know, if Texas A&M's drill team or militia is acting in some official capacity, I mean, there's no intent to intimidate there. That's a performance. There's a huge difference. Or that they're carrying out an official act on the part of the state.
See if anybody
That's
wants to
very
speak
different.
in opposition to this bill. Seeing nobody, the bill is before us.
Okay,
Move the report.
can we slow down a second and actually talk about it? Because, let me ask a question. Is it only the person that carries the firearm that's liable for the Class 4 felony, or is it anybody that's basically part of this crowd?
The bill speaks to firearms.
Or marching with any
Yeah.
firearm.
Yeah, the bill speaks to firearm.
No, it it speaks to assembles with one or more person with the intent to intimidate by
Right.
drilling or parading or marching with any firearm.
Right.
So it would seemingly apply to drilling or parading irrespective of whether
No, it wouldn't. No.
it's in connection with the
No,
firearm.
it wouldn't.
Okay. I mean, the word "or" to me is, it means it would be in addition to. I don't know what the drilling or parading part is. Marching with firearm, I totally understand, and that I have no problem with, but drilling or parading, I mean, look, you can parade as a First Amendment right. I don't see how you can stop somebody from parading.
Mr. Chairman, on line 24, if you add a comma after the word marching, it clarifies that the conduct is criminal if it's done with a firearm.
I'll move that amendment.
The comma?
And that's without regard to whether it's
Do we already have a comma, Bill?
visible or not.
Mr.
So
Chairman, the
it
bill is
doesn't-
silent on that. We could clarify.
And how about okay.
Mr. Chairman,
Fireworks?
Mr. Chairman, I don't think it matters if it's visible or not. If the intent to intimidate while you're carrying a weapon or an incendiary device or an explosive is the offense.
But it's, so just to Senator Peterson's point, let's be clear about what we're criminalizing. It's behavior intended to intimidate. If you have a firearm, irrespective of whether anybody knows you've got it, that is being criminalized.
Understood, Mr. Chair. I think the
Mr. Chairman.
comma makes the bill, I think that provides the clarification for the patron's intent.
Mr. Chairman.
Senator Stewart.
It would further complicate it. That would also be true if they had a firework in their pocket or a box of matches, potentially.
Lighter.
Well, Mr. Chairman, whether they knew it or not, the question is, you got to prove intent to intimidate. And you could argue, well, they didn't know there was a firearm, so there's no
Well,
intimidation
doesn't
there.
that
but
depend
then-
on what they yell? I mean, you can yell something that's meant to intimidate.
That's why I like the word malicious that I put in there that you voted down.
All right.
Mr. Chairman.
Senator Stewart.
If I could ask Mr. Benjamin, why doesn't their current brandishing statute cover what they're trying to get at?
Because,
Short
Mr.
of an
Chairman,
assembly, but
because, Mr. Chairman, brandishing requires an actual brandishing of the firearm. This bill would reach those who are visibly armed but not brandishing.
Well, brandishing is an intent to intimidate, using it with an intent to intimidate, isn't it?
I'll check to make sure.
And so, Mr. Chairman, the only other element is that you're adding an assembly to it versus a brandishing.
Yeah. All right.
Yes, Mr. Chairman, brandishing is where you brandish a firearm in a manner so as to reasonably induce fear in the mind of another.
So in this instance, assembling with firearms with the intent to intimidate another is a crime under Virginia law
That's what it says.
right now.
The current law provides that it's a crime for any person to point, hold, or brandish any firearm in such a manner as to reasonably induce fear in the mind of another.
Okay.
And I think the patron's point is that there is a separate crime or a greater crime when two or more people assemble and do so with the intent to intimidate. The brandishing applies to one person. The patron is pointing out that an assembly, especially a large assembly, is a graver offense, if I understand the patron.
That's correct.
Mr. Chairman.
Senator Stewart.
I can't recall this exactly, but Mr. Benjamin, isn't there a statute that talks about one or more persons gathering for purposes, they call it a riot statute generically, but it's when one or more persons gather together and commit a crime. And so that's why I think this is all covered already.
Bob, yeah.
Mr. Chairman, riot is the combination, actually, riot is the unlawful use by 3 or more people of force or violence, which jeopardizes the public safety, peace, or order.
But, Mr. Chairman, there's another statute which actually makes it a heightened offense if there's one or more persons committing a crime. And I can't call that statute right now.
All right.
I think that's unlawful assembly.
All right, the bill's before us.
Move report.
All right, it's been moved. Is there a second? And seconded, the bill be reported. And it needs to go to Finance, reported and re-referred to the Committee on Finance. Clerk will open the roll. Ayes 7, noes 8. All right. Bill fails to report.
Thank you,
Next.
Mr. Chairman, members of the committee.
Thank you. It's a provocative issue, and maybe we can work to get it right. Next, we've got Senator Stanley. Senator Donovan, last I heard, was delivering a baby. Not hers.
She wasn't showing.
So hopefully she'll be in shortly.
Mr. Chairman, members of the committee, Senate Bill 34 comes to me from our good friend Ward Armstrong, who had it. Don't take that totally. Who had an issue, and we've had a couple times where someone had been charged, was acquitted, and in the process of getting or attempting to get an expungement, they passed away. When they passed away, our judge, Judge Williams down there, found that that only the defendant may bring an expungement, and so certainly then that ability died at death. What this does is basically allow those family members, state representatives, to clear the person's name even after death, which some may say, well, what's the point? But I think to the family members, there is a point, and and you don't want anything to happen to anybody, but if somebody's name needed to be cleared posthumously, then it should be cleared posthumously, because you carry that reputation on in history, if you may not carry it past the grave.
Mr. Chairman, what about somebody who brings a slander suit and dies? The case dies, right?
Mr. Chairman, I'd answer the gentleman by saying this doesn't have to do with civil cases. This has to do with
I understand. I'm just
criminal cases.
throwing that out.
Yeah. And did I remind you, Ward Armstrong?
Well,
has me carry this bill.
Ward who?
Well, I mean, you say it doesn't have to do with civil cases, but doesn't it potentially have an impact on civil cases? So if you've got a charge,
Yeah, it's expungement's a
and
civil
they
matter.
die, and it's expunged, and you've got even a guilty plea, but it hadn't been entered or finalized, and you've got a assault and battery or something, you can't use the guilty plea if it's been expunged. What happens with the evidence that's been gathered through the criminal process? I mean, can that be used?
Mr. Chairman, I hope I can understand your
I hope you can too.
your hypothesis. It's a little tortured, but let's try to work through it. First, if you've entered a plea of guilty but you haven't been found guilty, then I guess if there's been no finding and the person dies during that period of time, and I believe the operation of law requires then the person's found not guilty. But that doesn't necessarily provide an expungement.
But isn't that an admission, a party admission, the fact that they pled pled guilty?
Mr. Chairman.
In a civil case, Mr. Chairman?
Mr. Chairman.
My understanding is convictions can be used against you where you've entered a plea, but if you're found guilty, those in civil cases cannot be used.
Mr. Chairman.
McDougall.
I'm not sure that I'm quite grasping the need for it, but the more direct thing would be individual charged with vehicular manslaughter or even just a DUI and somebody was injured. they go through the process before they get to sentencing, they pass away, maybe for reasons unrelated, and then somebody wants to go back and expunge that arrest or any sort of indication that the person had been charged. And I think that's probably more likely scenario where this would come in. But I'm not sure I'm understanding what is the benefit for somebody having something expunged after they passed away. I mean, Mr. Chairman, if the issue was that the person had started an expungement proceeding and then passed away before that finished, I might have some greater sympathy, but I don't know that that's what the senator's trying to accomplish.
Mr. Chairman, the bill is limited to persons who are entitled to bring a petition for expungement. And so if you have pled guilty, if you've been convicted, you're not entitled to bring a petition for expungement.
Mr. Chairman?
Sir McDougal.
If I have a case and the court is not issued a final order on that case, so I went in and pled guilty, the judge has not entered that final order and I die, then there's nothing there to prohibit an expungement, is there?
There is, Mr. Chairman. Senator McDougal, the charge would have to be dismissed or null prost.
And, Mr. Chairman,
Senator Peake.
and there's still a hearing. You have to give notice for an expungement. It then goes, and the Commonwealth's attorney is given notice, and it has to go in front of the judge. And so the judge can take into account that there was a guilty plea. And so all these things will be done.
Well, Mr. Chairman, I think
Senator Edwards.
Senator McDougal was saying the question is the timing of being entitled. The way it's written is if a person is already entitled to bring a petition for expungement, then thereafter dies. So the person would have to be entitled to the expungement while they're still alive.
Correct. Mr. Chairman, I would answer Senator Edwards by saying exactly, and that's said in two different sentences. One is if no petition had been brought but they were entitled, and then if one who was entitled to bring the petition died while it was pending. So it kind of takes up both of those scenarios. So you have to be entitled to bring the expungement petition.
So is this, I mean, a rampant problem, or is this one case that we're trying to remedy with legislation?
Mr. Chairman, I will answer the chairman by saying, while it was brought to me by a person who had had a case with a client who passed away during the expungement proceeding, certainly there was a philosophical discussion with the judge, and they believe that perhaps this was something that needed to be remedied so it wouldn't happen again.
Okay. All right. Anybody wish to speak in favor of this bill or in opposition?
They're all dead.
I move report. No, go ahead.
I have Louise's.
And we're going to,
hey, sorry.
I think Senator Marsden wanted his bill rolled in. I didn't mean to cut you off. Yes, sir.
David Ledbetter, Commonwealth's Attorney of the City of Waynesboro, here on behalf of the Virginia Association of Commonwealth's Attorneys. We are opposed to this bill. I think it's important first to understand procedurally what happens when a charge is pending against an individual and they die. The charge is then dismissed. That would make them otherwise eligible for the expungement. In addition, I think it's important, we often think of expungement, we think of in the terms of it gets wiped off of their state police record, their criminal history, but something else happens. The entire police report and the police file gets sealed. So you could have a situation, a man charged with rape prior to sentencing on that. He's been convicted prior to sentencing. He dies. That charge is dismissed. He makes him eligible at that point for the expungement. And if that happened, in addition, it would seal the entire file. You can imagine cases that the question came up would have implications on a civil matter. You could have a DUI that resulted in a death. The person that had the DUI dies before the sentencing. It'd have implications on the civil case for the possible wrongful death, and you can't get to the police report. The police officer can't talk about his findings. He can't talk about his investigation because the disclosure of that information in expungement is a Class 1 misdemeanor. Once disclosed,
Mr. Chairman.
Hang on. Stewart, McDougal, and Edwards.
Could it also have implications on the disbursement of insurance proceeds in certain instances or disbursements under wills?
You know, I don't know. I haven't done civil work in so many years. I'm not for certain how that would have an impact, but it potentially. And the other thing to bear in mind is we look at the expungement statute. Section 19.2, 392.1 of the Code of Virginia sets out the reasons for expungement. It's to protect innocent people, and it's to protect innocent people because the existence of that may affect their ability to obtain employment, credit, or education. None of those are implicated when the person is dead.
Senator McDougal.
Mr. Chairman, specifically, procedurally, if you die and a case is pending before that final order is entered, is it statutorily required that it be a dismissal entered, or do most courts accept null pros from a Commonwealth?
It's done both ways.
Okay.
There's not anything statutorily that requires it. There is a requirement that we clean up a record. So if it's pending in circuit court, my clerk will be coming to me for a motion, say, hey, I need to get this off my docket. And it's done both ways, by null pros and by just a straight up dismissal.
Mr. Chairman, so logistically, though, if a jury or a judge finds somebody guilty prior to that final sentencing order, the person dies, there is going to be one of the two, either a null pros or a dismissal that will not be left on the docket for time infinitum.
That is correct. There will be an order entered ending that case.
But, Mr. Chairman, that person would not have died entitled to bring the petition, and that's the distinction.
Right.
They have to be entitled to bring the petition prior to their death.
Right.
And so if they were not, while they were alive, entitled to bring the petition, and they die and it's dismissed, this bill does not afford any relief.
Correct. That's right.
Okay. Well, so what if they're terminal? I mean, well, strike that. All right, bills before us.
Mr. Chairman, I just want to say that this bill is only supposed to help good dead people and not bad dead people.
Were it
Just wanna
only
make sure
so.
that was clear.
All right, so Senator Stanley, you want to move to roll 98 into this bill
So
and the
moved.
report?
And actually, just put Senator Marsden's name on it, if you don't mind. Handing it over to you, my man.
That'll help, really, yeah.
No, I don't need to be.
All right, is there a second?
Second.
All right, it's been moved and seconded to roll 98 into 34 and report. Clerk will open the roll.
I have Lucas's, by the way.
Yeah, you're good. Ayes 5, noes 10. Good try.
Hey, you hate dead people. Okay. Thank you.
All right, now we're going to do, and we're about out of time, but we have three bills we're going to take up together. Senate Bills 597, 726, and 788. Senator Donovan, you want to step up and take this?
Mr. Chairman,
I'm sorry.
there was a substitute that was reported out of Ed and Health for Senator Donovan's bill. It should be on LIS for you, but if you need copies, I have them.
All right, anybody need a copy of 726? All right, Siobhan, go right ahead.
Thank you, Mr. Chairman. I am here today to present Senate Bill 726, and the essence of this bill is to change the previous indication for a doctor to give a recommendation for CBD oil from only intractable epilepsy to any diagnosed condition or disease. And this actually comes from the Joint Committee on Healthcare, where we reviewed the CBD oil process and the side effects and the risks after legislation that was similar last year. And it was the recommendation of that commission that we go ahead and allow the physicians to decide when the indication should be given. There's a couple of other minute details that are changed in here. One is changing concentration from 50 milligrams to 5 milligrams, just a smaller dosing so that it would be appropriate for pediatric population. And then there's one other that extends the dispersal or dispensing time window from 30 days to 90 days, which has been agreed to by the Board of Pharmacy. And I'm happy to answer any questions.
Anybody have any questions? Senator Marsden, anything to add?
Oh, may I just add that Senator Marsden should be a chief co-patron on this. He's done lion's share of work over the last many years. Thank you.
We'll also add Senator Vogel.
Could be
to
the
it as
kiss of
well.
death, I'm just saying.
All right, anybody in the audience wish to speak in favor of or in opposition to this bill? Step right up. Welcome.
Thank you, Mr. Chairman, members of the committee. My name is Tamara Netzel, and I have multiple sclerosis. I was diagnosed 5 years ago, and that was after waking up to the room spinning, and then I temporarily lost sight in my right eye for 2 weeks. Very short, yep. So I just want to just for these purposes, just to let you know some of my symptoms: tremor, blurry vision, cognitive issues, fatigue, neuropathic pain. So a lot of the prescription drugs, FDA-approved drugs that have been approved for my condition, give a lot of bad side effects. And if anybody can attest, if you watch any commercial for a drug, most of the 30 seconds is made up with the side effects. I was very compliant with any of the drugs that the doctors were giving me until this March. One of those drugs made my liver go into failure. That was kind of a wake-up call for me. And just some of the other drugs that I have taken, the side effects are blurry vision, hallucinations, narcolepsy, and my heart rate being too low. So I was on 7 drugs, and because of cannabis oil, have been able to drop 5 of those. I was a teacher for 16 years, a military wife for 26 years, and a mother of 2 boys who are both Eagle Scouts. I never thought that I would have to choose to break the law to take care of my own health. Imagine my joy when I saw that Virginia had passed a law to allow patients to have cannabis oil, and then disappointed that it's only for epilepsy. I thought, why not MS? And I will just add that the National MS Society released a statement in support of legalizing medical cannabis at the state level, regardless of barriers at the federal level. Thank you. Thank you.
Thank you very much. Anybody else wish to speak in favor of this?
Good morning, Mr. Chairman. Scott Johnson, General Counsel of the Medical Society of Virginia. We support this and appreciate the work that Dr. Donovan and Senator Marsden have done on this.
Mr. Chairman, I have a question to somebody. How do you get it to Virginia?
We passed legislation 2 years ago to have a vertically integrated compounding process here. The RFP for that will go out in March after this legislative session, but they've developed emergency regulations through the Board of Pharmacy to govern that process.
And what is the process when it goes into effect?
It will go into effect. There will be a request for proposals this March, and there will be 5 sites in Virginia that will be basically compounding pharmacies where this can be compounded.
Okay, thank you.
All right, so these 3 bills are before us. Anybody wish to speak in opposition to this bill?
Move to report.
Let's roll them together, report and re-refer to the Committee on Finance.
So moved.
We're going to use Senate Bill 726. All right, clerk will open the roll. Okay.
Yes, thank you, Mr. Chairman and
And
committee.
if we can, I know we're out of time. Let's do one more bill. Senator Peake, your bail bill, or your pretrial services.
What does this bill do? Is this any good?
Yes, Mr. Chairman, that is.
Okay. Hang on, right now, before, let's, I'm I'm advised that there's some uncertainty as to whether we rolled Senate Bill 98, Senator Marsden's into Senator Stanley, Senate Bill 34. Is there a motion to roll that in? Second? It's been moved and seconded. All in favor signify by saying aye. Aye. All opposed? That's rolled in. Thank you. Next, Senator Peake.
Mr. Chairman, yes, Senate Bill 783, is that what we're, Courts of Justice, yes.
All right, this is a crime commission bill, right?
Yes, Mr. Chairman.
All right, go right ahead.
Crime Commission bill, to require our pretrial programs to report to the Crime Commission and to us, so we'll know what they are doing. And it came out through the Crime Commission that there was a lack of accountability. I think this will bring in a measure of accountability.
Real quickly, my understanding is that pretrial agencies receive about $10 million every year in state funding. Currently, there's no requirement that they report on their activities and the extent to which they're complying with DCJS requirements. There's been no audit in a long time since I think this was removed from the responsibility of the Department of Corrections, and this would simply increase transparency and require an annual report. Is that basically right?
That's correct, Mr. Chairman. You said it better than I could have said it myself.
All right. And the goal is at least uniformity, some uniformity statewide with respect to practices so that we're not having people subjected to one level of supervision in one jurisdiction and a totally different level of supervision in different parts of the state, right?
Uniformity of supervision in all jurisdictions and to see what's going on with the money they're getting on an annual basis.
Anybody wish to speak in favor of this? All right. Real quick, in favor. Step right up.
Good afternoon, Chairman Obenshain, members of the committee, and my fellow criminal justice stakeholders. My name is David Bourne, and I serve as the chairman of the Legislative Committee for the Virginia Bail Association, which is an organization who provides a voice to the licensed regulated bail agents who work across the Commonwealth to assure the public safety through accountable release of people accused of crimes. I appear today on behalf of the association in strong support of SB 783. SB 783 is a necessary step to ensuring that accurate and uniform data is collected from pretrial services agencies across the state so that informed decisions can be made regarding criminal justice policy. This bill comes after a 2-year study that was recently released by or completed by the Virginia Crime Commission, which our association was briefly involved. The commission found that shockingly little data existed to determine whether these agents function properly with their legislative mandate. My colleagues and I were shocked to learn that the commission was unable to determine the statewide failure to appear rate within.
You like this?
I do like this.
Okay.
Okay. So the Virginia Bail Association strongly supports this bill.
Great. Thank you. Next.
Bill Weisband. I'm a highly regulated licensed bail agent here in Virginia, and I'd just like to say what Mr. Bourne said.
You like it too?
We do like the bill.
Awesome.
Thank you very much to the commission for bringing attention to it.
All right, thank you. Yes, sir.
Mr. Chairman, members of the commission, Rick Nagel, I'm the Director of Government Affairs for Mr. Bail. It is one of the largest bail bond agencies in the Commonwealth and employs over 400 agents in 16 different states. I also sit on the advisory board of the American Bail Agent Coalition, and we support this bill.
Okay, thanks. Yes, sir.
Hi, my name is James Inglefield. I'm just a regular bail bondsman, and I believe that this bill will help solidify what pretrial is actually out there doing. And I really appreciate you bringing this up to committee. And also I appreciate the Crime Commission for taking it up. Thank you very much.
All right, thank you. Now, anybody wish to speak in opposition to the bill? Yes, sir.
Good morning. My name is Thomas Fitzpatrick. I'm at the Department of Criminal Justice Services. And while we understand and support the underlying purpose for this bill and what you articulated, Mr. Chairman, earlier about uniformity with the reporting, we are working right now with the Crime Commission to reset how we do our programs. In terms of how the Crime Commission's report came out and the report they provided to you, there's a number of components that need to be reset in how we do that accountability. And we have already met with them a few times and look forward to doing that. With regards to annual reviews and how that works, in the legislative fiscal impact statement, it says that we can continue to do that. And while we can continue to do that in the way we have currently been doing it, as anticipated by the report from the Crime Commission that we need to have a more robust accountability program, I don't know how, with no fiscal impact, we can do more annual, or how we can do an annual review unless it's just a reporting of numbers. As we anticipate, what we'll have to do, it will include site visits to each of those programs to ensure that accountability.
So
that said, there's a few concerns, but we can work with the Crime Commission to do
So
that.
do you have any precautionary provisions in place to ensure uniformity now, or you all just rely on each agency to, try?
No, so we do have some components that we've been working on, and
I'm not asking what you've been working on. Are they in place?
So as reported to the Crime Commission, we provide technical assistance to programs, and we do training with the programs, and we do collect the information from those programs. What the Crime Commission reported was that how things like appearance rate, public safety, and compliance reports are calculated may have some difference in definitions. And so to your question, Mr. Chairman, we're working on the uniformity component of that.
Okay. All right, thanks.
Thank you.
Anybody else want to speak in opposition? Bill is before us. It's been moved and seconded that the bill be reported, and, does not need to go to finance, does it? All right, clerk will open the roll.
Go ahead, Glenn. Here you go. It's okay. All right, thanks.
All right. With that, I'm sorry if we didn't get to bills for folks who are in the room, but committee will rise.